Good afternoon, honorable members. Welcome to meeting. In terms of today's proceedings, we intend to have public hearings with those organizations and individuals that made written submissions on the Prevention and Combating of Hate Crimes and Hate Speech Bill. Just in terms of attendance, I should just indicate to honorable members that we have apologies from Honorable Ndungeni, Honorable Bartlett, Honorable Gershwin. Did
recording in progress.
Did Honorable Hadebe give an apology? I'm not sure. And Honorable Dangle gave an apology, but those four honorable members are currently out of the country. That being said, in terms of attendance, who's currently on the platform, we have Honorable Smith, Honorable Mikolakis, Honorable Moimang, who is the alternate for Honorable Bartlett. We have Honorable Dlamini, Honorable Badenhorst, Honorable Dudobu, Honorable Nita, who is the alternate for Honorable Ndungeni, and we have Honorable Maleka. I don't think we've received any other apologies from honorable members, but be that as it may, honorable members, before we get into the proceedings, I thought it was important that we take stock of where we are in terms of the process to date. Members will recall that on the 5th of September, we received input by the department on outstanding questions that we raised in a formal meeting on the Hate Crimes Bill. And at that meeting, the committee also took a decision to host public hearings the week after Provincial Week, which is this week. All these substantive submissions were also sent to members on the same day. Furthermore, the Secretariat communicated with stakeholders on the 8th of September and the 11th of September 2023. And as you will, in terms of the schedules that we received an overwhelming response, and thus over the 3 days we will receive presentations from 31 individuals, organizations. I should also indicate to honorable members that there are 5 organizations or individuals that indicated that they would not do an oral presentation. 7 did not respond despite follow-ups made by the Secretariat. And I think our committee secretary, Gershwin, can provide members with that list. On members to manage this process, we had communicated to individuals and organizations that we would provide them with 10 minutes to speak to their written submissions. However, there were 2 organizations that raised that the 10 minutes were too short. That's FOSA and the Association of Christian Media. In this regard, honorable members, I propose that we extend the time to a maximum of 50 minutes and thereafter allow members to engage and raise questions for clarity. I must also remind members that we are not at the stage of deliberation on this bill. Furthermore, honorable members will have also seen a correspondence by Honorable Mikolakis raising issues with regard to the schedule for oral submissions, specifically about the time for presentation and the committee engagement. I have referred the correspondence to legal services, and perhaps at this point, let me allow Ms. Isaacs from Parliamentary Legal Services to comment on this point. At this point, perhaps before that, let me also welcome the legal team, I think from the department, as well as from Parliament Legal Services. Ms. Isaacs, if I can just hand over to you if you have a comment to make.
Thank you, Chairperson. With regard to the letter, as per our discussion, I think the bottom line of public participation is that the members of the public are afforded a reasonable opportunity to participate in the lawmaking process. And the other aspect of public participation, which the courts have emphasized, is that the duty of Parliament to take measures to ensure that people have the ability to take advantage of the opportunities provided. So as indicated, there's 2 aspects. Firstly, the meaningful opportunity and the duty on Parliament to afford the public the opportunity to take advantage of public participation. With regard to this particular bill, there has been a lot of public interest, as seen by the number of people who have requested the opportunity to make an oral presentation. The committee has to weigh various factors in determining what is the most appropriate mechanism to facilitate public participation. In this regard, the committee has allowed for a long period to allow for the public to make written submissions. And this particular part of the process is the next step wherein the public is afforded a further opportunity to make an oral presentation and engage directly with the members of the public. So it's not two different processes, but it's the continuation of the public participation process, and this affords those who are requested to do so a further opportunity to engage on their submissions. The members who are the parties or the members of the public who requested this are not making a new submission, but they are speaking to something that has already been tabled to the committee, and we have their written documents into which we can always refer to. They are afforded an opportunity to refer to the salient points of their submission. So just in summary, public participation has to have a time frame and a limit. We are giving them a reasonable opportunity, and as you have indicated, you have agreed to extend the period to 15 minutes. And if the chairperson can manage the process to ensure that everyone has the opportunity to engage adequately.
Okay, no, thank you very much for that, Ms. Isaacs. I think having said that, honorable members, if you have any comment, perhaps you would want to, Honorable Mikolakis, I see your hands up. Okay, Honorable Mikolakis, if I can note you for now.
Thank you very much, Chairperson. Chairperson, yes, I note the comments of Ms. Isaacs. However, she did miss the fact that the court said that public participation does not only have to be a reasonable opportunity to give public input, but it should also be meaningful, and that the public should have the opportunity to influence the decisions and the thinking of the committee. Now, in that regard, I would submit to you that 10 minutes for a public presentation, firstly, is not enough, but my worry even more is that the amount of time that was allocated for our engagement with the stakeholders was 10 minutes. And even if you allow the extra 10 minutes that you've unofficially put into the program, because it's not mentioned as such in the program, 20 minutes for 13 select committee members to engage and ask questions, I think is very, very short. It does not even allow for a minute's question by each member, and that doesn't include the responses. So I do think that the amount of time that was allocated for us to meaningfully engage with the stakeholders, I think, is highly problematic, firstly. Secondly, there is a common thread, if you read through the documentation, by all the stakeholders, that I think everyone, or almost everyone, is in agreement that hate crimes and hate speech is a problem. What I do think our role as a committee should be, regardless of the argument whether this is procedurally sound or not, which I don't think it is, but I do think we also have an obligation as the committee to then bring people with perhaps different views on how to get there together around a table to find some other consensus so that we can get to a conclusion as to what the best version of this bill would be for the sake of the country. And I do think that this process does not allow for us to make any meaningful contribution in that regard. The third and last comment I would like to make is that you also received a email from one of my caucus members indicating to you, well, we all had a bit of a problem with Provincial Week taking up the whole of last week to prepare meaningfully for all of these interviews, and we're still going to read through the night to be properly prepared for tomorrow and Thursday. But one of my caucus members also indicated to you that he's suffering from dyslexia, so it makes it even more difficult for him to prepare. You did acknowledge the email, but you ignored the request, with all due respect. Apart from that, some of our members are overseas, so they are being entirely deprived of the opportunity to engage with the stakeholders meaningfully, and they also represent an electorate. So I honestly do not understand why the process is so rushed. If we have an obligation, a constitutional obligation, to meaningfully engage on behalf of the electorate, on behalf of the voters we represent, with these stakeholders, especially on a bill that's so controversial and so important. So I would like to request, Chairperson, that we reconsider the hasty way in which this is being done, and that we as a committee plan out the process, that we don't prolong it unnecessarily, not at all, but that we actually make sure that the public participation process on the NCOP's side is meaningful and complies with what the Constitution requires of us. The NA process is completely irrelevant to ours, but we do know that very recently the Constitutional Court did scold the NCOP for the fact that we do not do our public participation processes properly. And the last thing that I want is for this committee to again be before the Constitutional Court because we did not follow processes, or we did not request an extension, or we did not make sure that we fulfill our legislative duty as the Constitution requires. So I would like you to please, based on that, to put it before the committee that we rethink this whole process, and that we perhaps reconsider the way we've been going about it. Thank you, Chair.
Thank you very much, Honourable Mikalakis. That is one view. Honourable Dodo.
Thank you very much, Honourable Chair. Let me welcome this opportunity to also make some reflections. Firstly, Honourable Chair, there is no question this bill that is before us is extremely important for the country and for the protection of human rights. And it is quite important that we as members of parliament must be diligent, and we must expeditiously facilitate this particular bill. It is in the best interest of our country and our people to do that. We need to make sure that as Parliament, we play our role. We fast-track this process, which will result in us promulgating the Act itself, so that these provisions that are contained in it must be taken forward. I'm saying this, Honourable Chair, because as Honourable Mikalakis is stating, this process has attracted a lot of interest. A lot of people have made submissions, written submissions for now, and upon thousands of them. And that demonstrates the fact that there is a great deal of interest, and people want to participate and want to make their voice known in this particular instance. And we as members of parliament, we must at all material times take that into consideration. Now, we have a lot of parties, Honourable Chair, that have requested to make oral submissions on top of the written submissions that they have already made. And there's a lot of them. And I propose that we need to start somewhere. We need to begin this process and see how it goes, and this is not the end of it. And the way you have allocated the time, for me, it's quite okay. Let's start somewhere. I'm drawing the experience, Honourable Chair, of myself being a member of the JSC, the body that interviews judges in this country. When we invite them, over and above them submitting CVs, over and above submitting their biographies, the necessary documentations that are before us, we take about 30 minutes to interview a judge. Remember, a judge is a person who, if appointed, will serve the judiciary for the rest of his life until he retires and so on. This is quite important. We allocate 30 minutes for that and we manage it. And the chair of the interview is very flexible in terms of how he's doing this. Now, out of all the organizations, Honorable Chair, that have submitted, it's only 3 of them, about 40 of them that we are going to deal, that are complaining, that are saying 10 minutes is insufficient. And the rest have not indicated that there is a problem. My view is that let's start. Let's start with what we have, with a view that we will be flexible if time permits. And I was making an example of the JSC. It has got 23 members who represent diverse backgrounds, professions, organizations, and so on, including members of parliament. And we manage because we have documents already advanced to us and we are able to deal with these particular issues appropriately. And now, here are organizations that appear before us. We give them 10 minutes. Even the Concord that we see on TV every day, Honorable Chair, if the heads of arguments last for about 10 minutes, I think you should be done because we have your documentations already with you. And not all members are going to necessarily ask questions. And I'm saying, if we go beyond the 10 minutes, just as a chair, just try to be flexible. But for now, let us stick to what we have. I'm saying this because public participation is extremely important. It's a cornerstone of our democracy. It must be promoted. And we can't, for unjustifiable reasons, deny an organization that speaks to us and they, in a way, go beyond the 10 minutes that is required. But at least we need to have a threshold. And this threshold will help us and guide us to move forward and to finalize this particular to finalize this particular legislation that South Africans are anxiously waiting for as Parliament. I want to really appeal to members of Parliament that let's start somewhere. Let's see how it goes. And I have no doubt that with what we have and the structure that we have put in place, we'll manage everything to the best satisfaction of the process, and at the end of the day, produce quality, because that is what we want, and take into consideration and incorporate the views as they would have been presented by the organizations that will appear before us. And I want to really say to Honorable Mikalakis, he mustn't be worried. I think we are more capable, all of us as members of Parliament, to manage this particular process, and I think we are going to manage it with what we have. Take into consideration all the factors at play. Honorable Chair, thank you.
Thank you very much, Honorable Datobo. Is there any other member who would want to make a comment? Honorable Memang.
Thank you, Chair. My apology for not revealing the peak as I'm not well. But the point raised by Honorable Mikalakis about members that are abroad. As alternates, we are here by virtue of the rules of the National Council of Province. So that matter doesn't arise. Secondly, as we deliberate, I think what is quite critical is to accept the fact that this bill was introduced 5 years ago. 5 years ago, and therefore, given its significance, we need to continue. I think you have correctly pointed out, both from your position as the chair and also the legal advisor, that that you'll make a provision where it is necessary push it up to 15 minutes. So there's no need for us to continue delaying the start of the meeting. In fact, we are the one now as members, and we'll have an opportunity during the deliberations of the presentations to have our views put across. So let's start, Chair. Thank you.
Okay, thank you very much, honourable members, for those comments. I think our intention is not to suppress or stifle anyone, and it is to manage this process, and I think we will go ahead and do that accordingly. I see honourable members still have their hands up. Honourable Mikalakis and Honourable Badenhorst. I'm not sure, Honourable Mikalakis, perhaps if you could make a point.
Thank you, Chair. No, I just quickly want to respond, if I may, and thank you for giving me the opportunity. My problem is not with starting with the process. I'm very happy that we start with the process. We have to start, and the sooner the better. It's just the process itself and the time allocated to actually deal with it properly. I mean, Honourable Dodovo mentions the arguments that are short in the courts, but that is because the judges were given ample time to prepare their questions. We haven't, in this case, been given ample time to prepare for questions, so it makes it much more difficult than it would have. And it's also different from a normal job interview. This is very complex and controversial legislation. So those are two important points just to keep in mind. But Chairperson, if the committee then decides to continue, and I don't want to preempt what my colleague Honourable Badenhorst is going to say, but if the committee then does make the decision to continue on this basis, then I would like to request on behalf of myself, as well as Honourable Smith and Honourable Badenhorst, that our objection to this on the basis that I've set out in my letter just be recorded as well. Thank you very much.
Okay, just on that point, Honourable Mikalakis, this is a committee process, and I think in essence there are 3 committee members of the DA. Let me put it that way. That seems to have some reservations in terms of the allocation of time, which is fine. But other members don't seem to have those reservations. So I think we'll then continue with this process, but it's not to say that we're not cognizant of what you're raising. And I think, as honourable members have indicated, that we will try and be flexible in this process. I think what you're raising is that you are not necessarily prepared at this point to in terms of your questions, to engage on the presentations. But that doesn't go for all honourable members. And I think we should bear in mind that we still have time as a committee, where we're going to be deliberating more extensively on this piece of legislation. So yes, Honourable Badenhorst, maybe if you have a point, you could make it.
Okay, I've been covered by my colleague, Honourable Mikalakis. I just want to add to it that as members of Parliament, we have to oversee the process. We've got to make sure that the process, in fact, adheres to parliamentary principles. And at the moment, due to the fact that we've had very little time to prepare for what is about to take place, as members of Parliament, I feel that the process that we are now embarking on starts out flawed. And I want to just add to what my colleague said, Honourable Mikalakis. Please, could you minute that we feel, that, and myself in particular, and I'm sure my colleagues in the DA feel, that we are embarking on a flawed process now because of the fact that we didn't have enough time to prepare for this, taking Provincial Week last week into account, and the voluminous submissions that we had to peruse to get to this point. And I'll be quite honest with this committee, I haven't had time to go through everything properly yet. Just to read meaningfully, one would need at least a week to read through all the volumes. So I just want to make sure that the committee notes that. Thank you very much, Chair.
Thank you, Honourable Badenhorst. Honourable Smith.
Thank you, Honorable Chair. I hope I'm audible because my network is a bit sketchy. Can you hear me?
Yes.
Thank you, Chair. Chairperson, the Honorable Michalakis mentioned my letter to you because I'm the one that requested an extension due to my dyslexia. And it's already under pressure for all of us to prepare with everything going on. The short notice with the provincial week, as you know, was quite hectic, and we didn't have much time to do anything else. I never got a response from you whether you are considering my request or not. So I am concerned, that I've put a very legitimate request in, and I think it is just reasonable if we respect each other as South Africans, and especially if you have a disability, to consider that as well. Secondly, Chair, the fact that you mentioned that we will have further engagements on the bill doesn't solve the problem that our engagement should be with these stakeholders, because we want to engage with them purposefully and really get insight in terms of their view and how we need to approach this going forward. So it doesn't help we engage with it afterwards. The whole purpose of this whole practice that we're doing over the next 3 days, which is squished in, is to exactly engage with them purposefully and to get a proper feedback from them, and that needs us to be well prepared. It needs us to go through all the submissions, and it is not a few submissions. You know that it is a lot of submissions, and it makes it really difficult under normal circumstances, not even considering the fact that, in my case, dyslexia, that makes me much slower than any other person in terms of engaging. So I request again, and if that request is denied, then I also want to state my objection to the process, and that I am not satisfied if we're going to continue in this fashion. Thank you, Chair.
Thank you very much, Honorable Smith. Okay, Honorable Dodovo, followed by Honorable Tetwa. But before Honorable Dodovo, I must just indicate that some of the issues that you raise here are also matters for your relevant political party. So, it's difficult to respond to some of those. But let me take Honorable Dodovo.
Chair, I wanted to start there, Honorable Chair, that Parliament takes the issue of disabilities very, very serious. And any person who is impaired or unable or disabled to do certain things know what to do. There are certain processes that you must follow, that you alert Parliament about that difficulty, so that Parliament helps you to do that. I don't think that it is correct that just because of this process, you alert us of your disability and you expect us to do something about it under the circumstances. I'm saying, Honorable Chair, that on the 1st, if I'm not mistaken, on the 1st of this month, we were fully briefed in a meeting of the committee. We were fully briefed about the submissions which were made by different political parties, by different organizations about this particular bill. And now we went to our provincial week. Some of us work day in, day out. I spent sleepless nights, weeks actually, just preparing for this particular meeting. And when I received these things last week or 2 weeks ago, the submissions, I spent time to prepare to make sure that I'm ready for this, because I understand the importance of this legislation and that it must be facilitated as such. And I feel that we're placing unnecessary hurdles for the fact that other members of Parliament are overseas. They've got alternates. And that is permissible in terms of the rules of Parliament. And this alternates are here in the meeting, so that the work of Parliament must not be constrained and be inhibited by people who have gone overseas on a study tour, because we need to work, and that is what we are doing. I feel that is unfair, Honorable Chair, because we also know, Honorable Chair, that objections are made. The DA has placed certain objections. We have noted that as a chairperson, we know that. And I don't really understand now what is this? What is this all about? Because we need to continue. And it is us as members of Parliament that if we think that there are problems in terms of how we proceed forward, we can then say, let us review, let us look at how we can do this particular process better so that it is effective and impactful, and that at the end of the day, it produces the quality that is required. I feel that honorable members of the DA don't want this meeting to proceed because of their own reasons. I think, with due respect, Honorable Chair, you have invited organizations. Organizations are here. Out of the 43 organizations or 40 odd organizations that we are going to interact with, it's only 3 that have said we have a problem. And we are saying, let us find a way of becoming flexible and accommodate anyone who goes beyond the necessary 10 minutes. The rest of the people don't have a problem. And because they do understand that thousands upon thousands of our people have made submissions because of the importance that they attach to this particular legislation. Let us not create something that is unknown, that is abnormal, that is unusual. This is a normal process of Parliament. And like I said, Honorable Chair, if there is a problem, we will sit down and reflect and say, how can we do this more and better to improve, but not placing hurdle after hurdle because we don't want to proceed. As you pointed out, this legislation has been in place for a very long time. The problems that this legislation seeks to address are very, very important. They are at the heart of who we are and what we are as South Africa. And we need to move forward. That is why, even when people have gone abroad, we have decided to proceed forward, and that alternates are here to drive this particular process forward. And I really, really want to sincerely implore on honorable members, you have noted what they've got to say, and then that is recorded. And even in their deliberations, if they are not satisfied, they are free to articulate that and say this particular process was inhibited or disadvantaged by the following reasons that needs to be taken into consideration. We will do that. And even ourselves, if we think that this is a problem, we'll highlight that. It's not only the problem that will be up to them to deal with as such. That is why I feel very strong that some of us have spent sleepless nights just to prepare for this, because we attach a great deal of importance on this particular process. That is why we need to proceed forward. And if you are disabled, like I said, there are processes of Parliament that you need to follow to ensure that your concern is addressed and Parliament helps you as a member of Parliament, democratically elected, to can participate as such, Honorable Chair. Thank you. I strongly feel that we need to proceed in the best interest of our country and the matters that are before us that we need to deal with. Thank you.
We can't hear you, Chair.
Honorable Mthethwa, I'll take you and then we'll close on this matter, because I think members had sufficient time to speak. Honorable Mthethwa.
No, thanks, Chair. May I not switch off on my video? Honorable Dodovu has just covered me at length, Chair, and except to add one point that even the issue of a provincial week is surprising, Chair, that sometimes our colleagues may complain about the work of the provincial week, when we know for sure that some of them were not even there. So the issue, it really becoming unfair for us not to continue. That's why I'm saying, Chair, 90% of the input from Honorable Dodove has covered me. But
No,
the
no, it's
issue
fine.
of the provincial week is not a reason, Chair. We can think about anything else beside the provincial week.
No, no, it's fine, Honorable Mthethwa. I think based on that, honorable members, we will continue with this process. I should also indicate that this is not a flawed process, as indicated by one honorable member. When we are overseeing this process, I should also say that as this committee, we've always had run due process. We've also never been challenged, by a court in terms of procedure. The other issue, honorable members, is that what we're saying is that we will be flexible in this process and allow, the public, if they need a little bit more time to actually make the necessary inputs that they wish to make. Our members, I think that being said, I'm going to move on to the next phase and also welcome. Honorable Smith, you've already had your say. So
with all due respect, there were accusations made swing to my side about me not attending provincial week and a whole lot of.
You didn't mention.
So I've got a right to defend myself as well.
You didn't mention your name, and I propose that we also strike.
Who was he mentioning?
That. Yes, he didn't mention any names, so I'm not sure how your name came up. But Honorable Mthethwa just spoke generally. I'm going to go back to the business of what we are here for today, honorable members. Let me take this opportunity to welcome the various organizations that may be on the platform, or they may be joining us on this platform in terms of making their submission. Honorable members, today we have 7 organizations or individuals that will present to the committee. You have the schedule. I'll just indicate that it's the Association of Muslim Accountants and Lawyers South Africa, the Shima Kolenu, Ilita Labantu, Center for Social Justice, the South African Jewish Board of Directors. There's MBCFC, Dr. Nikki van der Westhuizen, and there's the Ecumenical Leadership Council. I think some of them are on the platform, and if you are, I'm just welcoming all of you to this meeting. We expect we expect in terms of your presentations that you actually speak to the submissions that you've made to the committee. We will allow you not more than 15 minutes to make the submission. And I think it would be very important, if you could also home in on what your issues are with the bill and what proposals you have, if any. I think that being said, let me call upon the Association of Muslim Accountants and Lawyers South Africa, Mr. Ashraf Parker. If you are on the platform, if you could, yes, I see you are on the platform. Over to you in terms of taking the committee on the submission that you've made on the bill. Mr. Parker? Mr. Parker, I see you've unmuted yourself, but I don't hear you. Mr. Parker? Okay, I think we seem to be having a challenge with Mr. Parker. Okay, I'll request maybe Gershwin to actually follow up with them. We have is Shima, is MX Jackie Benson Mabombo on the platform? I see you are on the platform.
I am here, Honorable Chair. Can you hear me?
Yes, thank you very much. I think we'll take your presentation. Our members will take this presentation, and then if Gershwin can follow up with Mr. Parker in terms of what his challenges are, because while he is unmuted, he's not. We don't hear him at all. Yes, over to you, Jackie Benson Mabombo, Shima Kolenu. Yes, Jackie.
Thank you, Honourable Chairperson and members of the Security and Justice Committee, and hopefully citizens of South Africa who are listening and watching this. Really, thank you for the opportunity. My name is Jackie Benson Mabombo. My pronouns are they, them, and I'm one of the co-founders of Shima Kolenu, which is an LGBTIQA+ activist organization that does its work through a Jewish lens. Shima Kolenu means hear our voices, and that's my appeal to you today, is to hear the voices of the people of South Africa. Our organization is founded on the principles of Chesed, which means love and compassion, Tikkun Olam, acting for societal benefit, Gimilut Chasadim, which is loving kindness, equality, equity, justice, and inclusion. And through the course of the next couple of days, you're going to hear submissions from many of my colleagues about the intricacies of this bill, a bill that I actually learned from one of my colleagues that's been a work in progress, was tabled 5 years ago for over a decade. Now, I'm not a lawyer. I'm not an expert on human rights. Our organization is, in fact, fairly young and has only been formalized for the last 18 months. So I'm not going to present stats and legalese to you. But I do hope to present to you some context as to why this bill should matter to each and every citizen and why its promulgation is now urgent. See, I am an activist, a citizen who's had to navigate my entire life and continues to navigate this world where being loved and accepted, even tolerated, is not something I can take for granted. Worse though, and this is the problem that I think we face, is that I don't even feel safe from hate and violence simply because of who I am and how I identify. A case in point is I got married a year ago. My spouse is Black and, like me, was assigned female at birth, although we both identify as gender non-conforming individuals. 40 years ago in this country, our union would have broken many laws. We would have been discriminated against on the basis of race, our gender identity, our sexual orientation, and we would have faced huge backlash of prejudice from our respective communities because we don't even share the same faith. Hate, as we've seen in our history, in the forms of laws that discriminate and prejudge people who are mostly faceless to the law. In many countries, even on this continent today, and this is why it is even more imperative that this law gets promulgated, I and many of my siblings would be criminals because one group of humans deems their superiority to be so much more important than the human rights of all people. Now, I'm also clear, I'm privileged that I've been born into the time I was born in. Whilst I grew up hearing the accounts of both my grandparents and parents' generations of how prejudice and discrimination in the form of anti-Semitism, racism, and homophobia was legislated, and where people have lived in fear for simply being themselves. My grandparents having fled their homes, my parents having witnessed people being locked up, people being murdered for being othered, hate crimes. I've also been a witness to a transition in a country that I love that's turned this around. And now as a citizen, I sit before you today, our elected officials, and I ask you to follow your mandate and safeguard the security of each and every person who lives here. In fact, not just the people all people who live here, not just the people who are citizens here, because we have many refugees who fled from other countries because of hate and discrimination. We want to make sure that the consequences to hate crimes, that people are held accountable and cannot simply incite violence, spread prejudice and discrimination under the guise of free speech and religion, that I shouldn't be getting WhatsApps in my inbox telling me about how bad LGBTI human beings are as a result of what religious authorities have deemed that I get to act as a human being, and that those are not justifications to stigmatize and justify how one group of people is superior to others. There needs to be law that protects all people. And the law is not just something good on paper, but most importantly, that it is implemented on the ground, that there is funding for this law, and that those that are held responsible for upholding it, our law enforcement officials, particularly our judiciary, our people in our judicial services, are properly trained in it so that we don't get re-stigmatized, we don't get re-traumatized and violated as victims. I don't want anybody, myself included, to be living in fear in a country where hate turns to violence, where every year at my synagogue on Pride Shabbat, we continue to read the names out of people who've been killed because they have simply identified as being queer, that they went into a bathroom and were misgendered and somebody came out and stabbed them. And there's no justice, no consequence, that lives are snuffed out because of such hate. So I appeal to you in the days of deliberation that you have and listening to meaningful dialogue, that you get your questions answered, but you're advocating for all the citizens of this country, regardless of your or their beliefs, but rather for all of our humanity. So I invite us to get this bill promulgated and properly implemented quickly. Then myself and my colleagues can be partners to government and focus on our work to creating allyship, training all our people on how to connect and love one another, and learn that it's okay to have differences and still have love for humanity and human beings. Finally, I'd just like to end off with a prayer that I shared this Rosh Hashanah, which has just been this last weekend, on diversity and inclusivity, and hope that it brings something to the space for the next 2 days. Eloheinu ve'Elohei Avotenu ve'Imotenu, our God and God of our ancestors, creator of humankind. Our tradition teaches us that we are all descended from Ha'adam, the first human, so that no individual or group can rightfully claim superiority over another. Give us the courage to speak out against any form of prejudice and discrimination within and without our communities and our country. We commit ourselves to listen respectfully to each other, working to repair the damage and trauma of the past in order to make our country a welcoming and safe space for all. Brucha atya Eloheinu, Ruach haolam, asher kedishanu, b'mitzvotecha v'tzivanu lirdof tzedek, u'lekabed kol nefesh v'shutafet. You are blessed, O God, Spirit of the world, who makes us all holy with your mitzvot and commands us to pursue justice and to honor all people and connections. And let us all say, Amen. So thank you very much for your time. And if anyone has any questions about what we shared, please, also all of the information has been put more succinctly into our written submission.
Thank you very much, Jackie, for your presentation. Let me just see if honourable members, if you have any questions that you would want to ask. I see Honourable Mikolakis, your hand is up. Honourable Mikolakis?
Thank you very much, Chair. Thank you very much for that presentation, Jackie. I hope you had a wonderful Rosh Hashanah. And I was very surprised to hear that your organization is so young. You're doing very important work, and I hope you will have a very prosperous year ahead. I just have a few questions. The first one is, I was quite surprised, and we experienced it with other bills as well, a very important point that you make with regards to training and capacitating the law enforcement to be able to deal with this problem. And I also find that a lot of the time the training is not there, and that makes specifically criminal law sometimes very difficult to enforce. So thank you very much for pointing that out. I think it's quite important. I am going to ask you one or two questions of some of the arguments that some of the other organizations are making, just to get your views on that as well. And the first one is that although there is, it is a serious societal problem that needs to be urgently addressed. But there are a few flaws pointed out in the legislation. And as a lawmaker, I struggle with trying to balance the fact that we need to, because law like this is something that's going to stay with us for a very, very long time. So we need to make sure that the best possible version is put out there. It's no use, it's on the law books, but it can't be enforced because the law enforcement isn't trained, or there's a flaw in itself, because that creates a different kind of a problem. So I'm struggling to also not understand, but it's a bit of a conflict at the moment that we need to get the best possible version of the bill out there, but that also takes time. So that's the one point that I want you to comment on, because you put a lot of emphasis on the urgency, and I understand the urgency. But as a lawmaker, I also need to look at bringing the best possible version through Parliament. The other question that I have is that many organizations point out that most of these crimes are already covered in our law, but that it's a societal issue that needs to be addressed, and that merely promulgating law is not going to address the problems that society creates, especially for people of the LGBTQI community. And I would like to hear your comments and your response to that, because I do think that even if the law is published, you're not addressing, or even though the law is passed, you're not addressing the societal issues that are underlying. In what way do you think the passing of the law would assist in that process? And in what way do you think the law can only take us up to a certain point where there will still be a shortcoming? And can those shortcomings be addressed further in legislation? Then just a final question, Chairperson, is that a lot of the objection towards the bill is based on the fact that it might, and some might argue it definitely does, curtail the right to freedom of expression. That can never be done at the cost of other human beings or other citizens. And I would like to know from Jackie how they think we can find the balance between the freedom of expression, which is important in a democracy, but also respect for who individuals are, which is also another cornerstone of our democracy, because that's the important and fundamental balancing act that we're trying to create here through the bill. If we don't get that right, it will fundamentally be problematic, and we don't want legislation that will create even more problems than it creates solutions. So I would just like for now to get her comments and her views on those objections raised by some of the other organizations. Thank you, Chair.
Okay, no, thank you very much, Honorable Mikolakis and MX Jackie. Obviously, I know some of the issues that the member is raising, and I think all members of the committee will note that these are issues that we as a committee should take forward in terms of our deliberations. However, if you wish to respond, I'm going to give you a platform, but I see Honorable Moimang, I forgot to see if there are any other members that would want to engage you. Okay, let me take Honorable Moimang. Sorry about that, Ma'am Jackie. Honorable Moimang.
Thank you, Chair. And my appreciation for the opportunity given. I guess our engagement or our clarity seeking questions has to be restricted to the presentation from the presenter, and it's an area that I believe we need to improve on as we engage for the next coming 3 days. Because some of the questions, Chair, are covered in the app itself, because I mean, in the bill itself, the bill makes provision for some of the questions posed, because it makes provision for the strengthening of the criminal justice systems in terms of how it responds to hate crimes. It talks to more accountability for perpetrators. It isolates measures to facilitate the reporting and investigation of such crimes. I think we should be doing that, because now if as members we are going to pose these questions to the members, whereas the bill that we are inviting members to comment on make such provision, it's sort of I believe it's an unfair question to the presenters. Secondly, also, there will be some of the judgment that has made pronouncement on how hate speech is conceptualized and understood, which basically also played a role in terms of how the definition, whether it is Section 3 or Section 4 of the bill, is crafted, is informed by some of those court judgments. So I just wanted to raise this point to say, as we engage with the presenters, let's be mindful of the fact of the work that both the bill suggests to us, which clearly captures some of the pronouncement made by our courts. So, like as the presenters indicated right at the beginning, she said she's not an attorney, she's an activist, and therefore, I just said let's throw this word of caution. Chair, thank you.
No, it's fine, Honorable Moimang. I think I covered what you were saying on based on what I said. Honorable Smith, do you have a question that you would want to ask? Honorable Mikalakis, I think you want to respond to Honorable Moimang, so please don't. Honorable Smith?
Thank you, Honorable Chair. Jackie, I've got a specific question, because I think one of the things that we as legislatures struggle with is that balance between freedom of speech and then, you know, moving over to hate speech. So where my fear in terms of some of the things within the bill is the fact that if we offend any person, because there's where does that line between offend and hate speech come? Yeah, where's that separation? Because that is what I'm worried about, is exactly that, because that's one of the fundamental rights that I think we all stand for, is to have the freedom of speech, to say what we feel, what we believe in, without causing hate and you know, and violence against individuals based on who they are. I myself are part of the LGBTI community, so I totally understand where you come from. I've also lived through a lot of that, and you know, it's a tough space to be in. So my question to you is, you know, where will the space move over from offending somebody towards crime be, hate crime or hate speech be, in your view? Because that is something that we have to consider within this bill and to draw that line between the two. Thank you.
Thank you very much. Jackie, over to you. If you have any responses you would like to make. I know you said you're not a legal person, but please, over to you.
Sure, thank you. And I really do appreciate all the questions and comments and the grappling that this committee and our parliament sits with in ensuring that we're creating legislation that does hold space for all views and that it doesn't get to a point where there is hate. And I think that's the, Honorable Smith, I think your question is a very important one and one where we have to self-reflect on, in terms of the way that if I am saying something is a belief and I'm putting it out there in the world, that is the truth about a certain person or people, that it then inflicts some experience of harm on that person, whether it is emotional, psychosocial harm, physical harm, that is hate. Where I say something to you that you might take offense, but I can hear that you and I can have a conversation, a dialogue about that, and I can then get your opinion or view about that is a different kind of conversation and dialogue. And part of, I think, what we need to be cognizant of, and as I was deliberating what I was going to be saying to you, it was with great sadness that I think it's a point in our humanity that we're having to put bills together about preventing hate speech, that we're not actually putting bills together about how to foster love and more care in the world and how to create loving kindness with one another. But we do need a framework of accountability. And I believe that the LGBTI community, particularly, and the Jewish community that I'm part of, is looking for a framework from government to hold accountable for what people say and how they act. We cannot just act any which way. If I am driving on the highway, I can't be driving under the influence of alcohol. I can't be speeding at 130 in a 100K zone and not expect that there are some consequences to my actions. And so I think we need to be holding this bill to the point that it is the consequences of actions that we're looking for, that we can then hold people accountable, and we can then focus on the work that needs to be done, and that's the work at ground level. I don't think that, this is about the stick and not about the carrot. We believe part of our work at Shema Kolenu is about advocacy and engagement with communities. Me showing up as a Jewish person in the LGBTI community, where Jewish people don't ordinarily show up, brings a whole relationship and conversation that doesn't exist before, because it tends to be a very Christo normative space. And that's a different kind of work that we do. But I can focus on that work if I know that I'm safeguarded by my government as a citizen, that I don't have to be scared, and that I don't have to have people hating me just because of who I am and inciting violence against me. And that's what we are wanting. We're wanting protection, and we're wanting to be able to use the law to protect ourselves, where currently that doesn't feel like that's the case. And we also require that then this is the education of those that are responsible for the law enforcement at all levels to actually be properly trained, like it is mandated that is required. And it's something we would like to, we certainly as Shema Kolenu would like to see in terms of the law, and funding is made available for it, because the re-traumatization of victims of such violence has an impact not just on the person, but on the community, and the psychosocial impact on people's mental health and well-being. And the cost of that to our country, we cannot equate, we cannot put a rand sign to. These are the things that this law will start to actually support us in making sure that we have access to. But the real work needs to be done on the ground, in our education system, in our educating of the people who are delivering services to our communities. That's where the sensitization and training needs to happen. We need to be learning how to debate ideas, and we need to be able to learn to agree with disagreeing and be okay with that, but actually at the end of the day, walk away shaking hands. And that's one of the things that I also appeal to you as members of the NCOP and our National Assembly, that we see more of a demonstration of that from our parliament when we're sitting watching parliament, and not the kind of bickering and fighting that we see that goes on, because that's also a demonstration to the members of our country about how engagement happens. Thank you.
Thank you very much for raising those points. Let me thank you for your input, as well as for trying to respond as well to what members have raised. And I think with that being said, I think as a community we would obviously also consider your inputs that you've made in terms of this bill as we deliberate further on this piece of legislation. But thank you very much, Jackie, for taking this time to address the committee. Thank you. I think, honourable members, we'll then move on to Mr. Parker, who I think is back on the platform. I hope this time we'll be able to hear him. Mr. Parker from the Association of Muslim Accountants, yes?
Good afternoon, Chair. Can you hear me now?
Yes, we can. Please continue.
Thank you, Chair. Good afternoon, Chairperson, as well as other members on this committee. My name is Ashraf Parker, and I'm an attorney, and I'm also an executive member of an association called AMO. That's the National Association of Muslim Accountants and Lawyers. I've been requested, and on their behalf, to make oral submissions relating to the written submissions which we have submitted to this particular committee. At the outset, Chairperson, I intend to just give a brief summary of the submissions that we have made, and I do not intend to read out the entire submission. So as an introduction, the challenge that we have is the issue of the constitutionality of the bill in particular. The bill, specifically in paragraph 3, refers to the offence of hate crime, and paragraph 3, subsection 1, sets it out. And the challenges that we have is in particular relating to 3.1, subsection P and subsection Q. Before I get to that, it is our considered view that this bill affects the freedom of religion and freedom of speech rights of the Muslim community in relation to the LGBTQ movement plus other persons, and that the constitutional freedoms advocated for in this paper on behalf of Muslims apply equally to other peoples who hold the same or similar views regarding LGBTQ conduct as Muslims do. So when we made our submissions, we believe that we speak for Muslims as well as for other persons. To concentrate on the issues that we have with the bill in its current form, it is important for me to place on record that the Islamic faith is followed by billions of Muslims all over the world, obviously, and South Africa as well. And that the Islamic law in particular prohibits homosexual conduct and the freedom of Muslims to teach and preach this, which is actually recognized by the Constitution in terms of section 15 and 16. It is my submission that the bill limits these freedoms for Muslims. We submit in particular that the words harm and hatred are not sufficiently defined and result in vagueness and uncertainty. It is our view that it could render this criminal statute unlawful. We submit that the exemptions provided for are vague and uncertain, and its application results in unfair discrimination, which renders it unconstitutional. Chairperson, as I've said before, the purpose of our submissions is to identify those areas of the bill which we believe stunts religious freedoms and expression of rights of Muslims and other persons as well, as recognized by the Constitution. It is my intention to hone in on 3 aspects of the bill, which particularly refers to hate speech, the aspect of harm and hatred, as well as the element of good faith, as well as the element of bona fide. So, in essence, if I refer to the bill, we believe that this bill, it perpetuates the confusion, and I will show exactly why. Our submission that the bill in its current form coerces Muslims to act in a particular manner that is contrary to their religion and constrains Muslims from the full manifestation and expression of their religion and their religious rights under the Constitution. Our objection in essence surrounds the vagueness and ambiguity of the words harm and hatred and the weak and circular nature of the religious exclusion. Before I go any further, I just need to place on the record that Islam in particular, whilst it prohibits homosexuality and the like, we do not believe that as an organization, or we believe that any person should have the right to go onto a public platform, to go in a church or a mosque or a synagogue or a temple, to personally identify persons who may be following LGBTQT. We do not, I think, subscribe to that view. However, where we feel the bill falls short is that the words, the harm, the hate speech, bona fide and good faith is not clearly defined, and I will just spend a few minutes on that, which will, in essence, it represents our submissions. So the bill in particular says that any person who intentionally publishes, propagates, or advocates anything or communicates to persons in a manner that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm or to promote or propagate hatred is guilty of an offense of hate speech. The word harm, as defined by the bill, means any emotional, psychological, physical, social, or economic harm. The definition of the word harm in the bill does not provide clear and proper definition. That is one of our challenges with it. It is circular in its nature, in that it says that the word harm means, etc., etc. The words adjectives, emotional, psychological, physical, social, economic, simply create categories of harm. They do not tell us what harm is. And based on that, without a clear definition of the word harm, we are of the view that the sections, in particular 42A and 42D, are vague and unclear. Regarding this vagueness, the Constitutional Court said that a norm or rule cannot be regarded as a law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able, if need be, with appropriate advice, to foresee to a degree that is reasonable in the circumstances, the consequences which given action may entail. This was said in the particular decision of State President versus Hugo. The same court said in another case, it is an important principle of the rule of law that rules be stated in a clear and accessible manner. I wish to move on to the issue of good faith and the vagueness of it. The vagueness and uncertainty in this section relate to the following: the meaning and the effects of the word good faith, the meaning and the effects of the word bona fide, as well as bona fide relates to the rest of the section. Good faith means neither Section 1 nor Section 4 define the sufficient clarity of what good faith is. Therefore, if the statute is intended to regulate the conduct of citizens and impose criminal sanctions, then it will require increased precision and clarity. Citizens must know beforehand what conduct will constitute a crime. The effect of this uncertainty regarding the type of conduct which will qualify as having been done in good faith will be that Muslims and potentially others will be self-censored. A further result of this uncertainty will be that those may feel aggrieved by the free expression and other manifestations by Muslim persons and other persons in terms of Section 15.1 rights and Section 16 will be castigated in public and dragged before the courts. Then secondly, what is the meaning of the word bona fide? And bona fide, as we all know, is the Latin equivalent of good faith. It is unclear whether bona fide in Section 42D serves only as a qualification for the word interpretation or because of the conjunctive and as a qualification for the words proselytizing and espousing as well. As a qualification for the word interpretation, it implies that state apparatuses, the police, the NPA, as well as the courts and other tribunals will be tasked with deciding what qualifies as bona fide interpretation of a religious tenet, belief, teaching, doctrine, or writing. This will be unlawful in that it will violate Section 15 of the Constitution as well as the doctrine of non-entanglement. Lastly, Chair, I wish to hone in on the issue of what is hate speech, harm, and hatred. So the bill, obviously, it says that any person, in terms of Section 4, who intentionally publishes or propagates, advocates anything, or communicates to us more persons in a manner that could reasonably construe to demonstrate a clear intention to be harmful or incite harm. And for that reason, one needs to understand clearly what is the definition of the word harm and what is the definition of the word hatred. And we feel that the bill doesn't go so far as to clearly identify the description and the meaning of the words harm and the meaning of the words harmful. And for that reason, Chairperson, it is our view that the legislation should actually revisit that part of the bill so as to give the public clear guidance on the interpretation of the bill, in particular the three aspects relating to hatred, harm, good faith, and bona fides. In conclusion, Chairperson, I wish to perhaps just end off that, you know, we oppose the current draft bill in its current form, and we are of the view that it will not survive a constitutional challenge because in a criminal statute, the words harm and hatred is too vague and uncertain. The conduct that the particular sections will apply to are not defined with sufficient precision. We submit that the exclusion for religious conduct, it is a bit vague and uncertain and circular in nature, and that the construction of this exclusion treats the rights of religious persons on a lower rung than the rights of academics and reporters. For that, Chairperson, I yield back to you, having expressed our concern with those aspects of the bill. Thank you, Chairperson.
So thank you very much, Mr. Parker, for your presentation. Yeah, I think let me just see, honourable members, if you have any questions you would want to, for clarity, that you would want to pose to Mr. Parker. Honourable Dodovo.
Yeah, thank you very much, Honourable Chair. I have a network problem. I'm not gonna switch on my video if you allow me. Honourable Chairperson, my concern to the presenter is on the basis of the fact that he says the word harm and hatred are not clearly defined, and the bill in its current form doesn't clearly explain what a hate speech is, what harm is, and what hatred is. I understand that is his assertion, but what he doesn't do is to say, in my view, this is what harm is, this is what hatred is, this is what hate speech is, and therefore I propose that it must cover the following, and this is what the bill has got to say. I'm not sure whether it's possible now or in the future that we can allow you, if it is possible, to present his own proposals about this particular word so that we must take them into account. Thank you, Chair.
Thank you very much, Honourable Dodovo. Honourable Mikolakis.
Thank you very much, Chair. Chair, yes, my first question is very much the same as the question that Honourable Dodovo just had now. There are a few terms that were mentioned that should be defined a bit more in detail and a bit more clearly defined. And I would like to inquire whether Mr. Parker actually has a few proposals for us in how those specific concepts can be defined properly in the context of the bill. Then just another question that relates to the freedom of religion, which he placed a lot of emphasis on, which is an important question that we need to deal with. Some might argue that clause 4, subclause 2 of the bill covers religious expression, and I'll ask this question in various forms to various stakeholders just to get an idea with regards to their views. But to Mr. Parker specifically, I want to ask whether he thinks that the current clause 4, subclause 2, deals sufficiently with allowing the freedom of religion in that sense. And if he disagrees, can he perhaps share with us why he thinks it's not sufficient, and perhaps what aspects of this specific clause needs to be relooked at? Then just Chairperson, I think if I remember correctly, it was briefly touched in the submissions towards the end. I'm not quite sure, but I would like to ask his views on the 8 years maximum sentence for a first offence. I think it is quite an important issue that was not elaborated on sufficiently in the presentation, which I would like to hear a bit more of. Chairperson, and then also just a final question. This was also touched on in the submissions, the written submissions itself. I would like to just get a sense of Mr. Parker's opinion that in what sense does the broadening of the grounds or the mention of the grounds that might be covered under a single concept such as sex or sexuality become a problem? I do know that some submissions have been made that it takes it beyond what the Constitution protects. I just want to get his clarity and his opinion on those 4 questions, please. Thank you.
Thank you very much, Honourable Mikalakas. I think you also covered in terms of the questions asked around clause 4 section 4 subclause 2, and whether if the issues related to the definitions have been covered, would he still feel that the exemption in clause 4 subclause 2 would cover those religious aspects in terms of freedom of religion? I don't see any other member. Over to you, Mr. Parker.
Thank you, Chairperson and members. Chairperson, if I may suggest, in the interest of time, and with your consent and your committee's consent, we would like perhaps to broaden submissions on what we perceive should be the definition of the issues relating to hate, bona fides, etc., etc. I think the general challenge that we have, Chairperson and members, is that I think a lot of clergy in particular are a bit apprehensive. They're a bit undecided. They do not have a bit clear direction, and they look towards, I think, the legal people to give a bit of guidance, etc., to actually advise them what, and that is why I made the point earlier on. I think from an Islamic perspective, and I think a general perspective, is that you cannot publicly identify persons and slander them in terms of this act. So if with your consent, we would like to make further submissions on those aspects which has been raised by your members. The meeting is recorded. So I would like to be given that opportunity, and then maybe that will assist this committee to be able to consider them and with a view to finalizing this bill. So yes, that would be my response at this stage in the interest of time. Thank you, Chairperson.
Okay, no, thank you very much, Mr. Parker, for your inputs, for making the submissions, for accepting our invitation for this oral submission, and for responding to members. Yes, I think perhaps as indicated, you could. There's been a request for additional information from yourself, from members. I'm sure we could allow it in terms of what are your proposals around some of the definitions and maybe your responses to some of the other issues that members have actually raised. I'm sure we're going to have to put a timeline to that as well, because it surely cannot be open-ended. And I think, honourable members, perhaps I don't know. Perhaps we could give yourselves a week, if that would be okay, Mr. Parker, and then to try and make this additional input.
That should be in order, Chairperson.
All right. Thank you, Mr. Parker.
Thank you, Chairperson. Thank you, members.
Okay. Our members will then move on to the next organization, Litha Labantu. We have Ms. Natsai Chakapfava. I'm not sure if you are on the platform, ma'am. Okay, I see. Over to yourself. We're giving you a maximum of 15 minutes to make your input. So yes, over to you, ma'am.
Okay, thank you, Chair. I also am having connectivity issues, so I will try not to switch on my video so that I can remain on the platform, Chair, if that is okay.
Please continue.
All right. I would like to acknowledge the chairperson of the committee, members of civil society.
Honorable Chair.
Ms. Natsai, could you please hold on a second? Honorable Dodo.
Yes, I was suggesting that even though some presenters have got difficulties with connectivity, if you can just see their faces, they can then switch off. It's okay. We want to connect with them. We want to see them.
Yeah, I think we didn't do that with Mr. Parker either, but I see he's off the platform. But anyway, ma'am, if possible, you could just put on your video so we put a face to the name. Okay, and
I don't know if I'm being seen properly.
Yes, we can see you. Thank you. I hear that your signal is not okay. So you're welcome to put off your video.
Thank you, Chair. I was just acknowledging you, Chairperson, the committee members, other members from civil society, and distinguished guests on the platform. My name is Natsai Chakapfava, and I'm a legal advisor at Litha Labantu within the Policy and Advocacy Department. Litha Labantu welcomes the opportunity to comment on the prevention and combating in the country. A little bit about Litha Labantu. It was established in 1989, and it is a social justice community organization based in Guguletu Township. It has a specific focus on addressing violence against women, children, vulnerable groups, and supporting those affected by it. Litha Labantu finds its resolve and strength to comment on this bill because the scope of our work is centered around meeting the needs of communities that are affected by high levels of violence in the form of domestic violence and gender-based violence. Gender-based violence, as we all as people, most communities in South Africa, and we have also seen how over the years the plight faced by women, children, the vulnerable, and when I talk of the vulnerable, I will specifically mention the elderly and the LGBT as our communities. There's so many forms of secondary and lots of trauma suffered, and we see these issues fundraising. While we acknowledge that the prevalence of violence and all forms of abuse on women, children, and the vulnerable is not a uniquely South African problem, but a worldwide epidemic. We also where they properly.
Okay, honourable members, I think we've lost. I'm not seeing.
Yes, Jane, we can't hear clearly what she's saying.
Yeah, no, I think we've also lost her off the platform. Okay, I'm going to, on this one, I'll just request perhaps Gershwin, maybe make a follow-up. I see Mr. Parker, you're on the platform. Just show us your face as members had requested so that we're able to know who you are, put a face to the voice into the submission. Mr. Parker? Okay, I don't know if Mr. Parker is hearing me, but okay, honourable members, I'll request Gershwin then to make a follow-up with Lita Labantu. And hopefully once they get back onto the platform, they can continue with the presentation. What I want to see, are you back? Okay. All right. Please continue. We couldn't hear a bit of what you said.
Yes, I'm
previously.
back. Okay.
Please continue, Mark.
Should maybe I just start all over again?
Okay. I think it was just the last bit of what you
the
said.
organization is in favor of the bill as it aligns. Oh, okay.
Okay, I think we've lost you again. Yeah, your signal is a bit of a problem. Okay. Well, remember, I think we'll go to the next presenter for now. We'll make a follow-up with Lita Labantu. We have the Center for Social Justice, the Law Faculty Trust Chair in Social Justice, Professor Madonsela. Yes, you are on the platform. Okay. Ma'am, thank you for making an input into this bill. And also for accepting the invite of the committee to make an oral presentation based on your written submission. I think, as I'm sure you got the gist, that we're allowing you at least 15 minutes to make that presentation. Let me hand over to your good self, Professor Madonsela. Okay. Professor Madonsela? All right. I think they were scheduled to in terms of the program to be on at 14:40. So I suspect that they probably logged in and are not necessarily. They probably waiting for the time that they need to make a presentation. Can I just verify whether the representative from the NBCFC is present?
Yes, Honourable Speaker, yes, we are. We can be ready in about a minute from now, if you'd like.
It's Dr. van der Westhuizen.
Yes, that's correct. Dr. Nikki van der Westhuizen, who's the senior pastor of NBCFC.
Okay. All right. Dr. van der Westhuizen, if you could indulge us, and if you, yes, we can give you a minute to get your thing together, and then perhaps we could take an input from yourself for now.
Just give me a minute and I'll be back online. Thank you. With Dr. Nikki, I'm actually representing him as well as part of the ministry. So he will come online in the next minutes. All right.
Okay. Thank you.
Chairperson, sorry to interrupt. It's Gershwin speaking. Ms. Alana Baranov is also on the platform. She was meant to go next, Chair.
Who is that? Sorry, Gershwin, I didn't hear that.
Lana Baranov.
Oh, the South African Jewish Board of Deputies. I don't know how I missed that one. All right. Okay. I am sorry about that.
Honourable Speaker, we can wait until her turn is done, and we can go afterwards if that suits you as well.
It's chairperson and not speaker. I don't want to be promoted to a speaker yet. But thank you. Thanks for understanding. Let me then take the Ms. Alana Baranov from the South African Jewish Board of Deputies. Once again, welcome, and let me hand the platform over to you. Keshav?
Good afternoon, it's Alana Baranov here. Please may I ask for one moment just to get my presentation up on the screen? Thank you so much.
Geshwin, does she have, is she able to share the screen?
Yes, Chairperson, I've given her rights now.
Okay. But Ms. Baranov, if you could maybe just also show us your face at least, so we know who we're speaking to for the moment.
Apologies, I'm just having a trouble with my connection as well. I will put on the camera in one moment.
Okay. Okay. Welcome. Can you unmute? We cannot hear you.
Apologies, I hope that you can see me okay.
Yes, we can. Thank you.
Thank you so much. I'm going to share my screen, if that is okay. Good afternoon. In the 2 decades since our first democratic elections, South Africa has made significant progress in enshrining fundamental human rights for all. However, in stark contrast to our progressive policies, incidences of hate crimes and hate speech have only grown in recent years. The South African Jewish Board of Deputies is the representative body and the human rights voice of the South African Jewish community. In this capacity, the SAJBD is the founding and steering committee member of the Hate Crimes Working Group, a multi-sectoral network of civil society organizations advocating for hate crimes legislation. My name is Alana Baranov, and I am proud to represent the South African Jewish Board of Deputies as the co-deputy chair of the Hate Crimes Working Group, and to present my organization's oral submission to the NCOP on the Prevention and Combating of Hate Crimes and Hate Speech Bill. As an organization whose mandate is to protect the civil liberties of South African Jewry through combating anti-Semitism and fighting discrimination, we welcome the publication of the bill and are grateful for the opportunity to share our oral submission with you today. I would like to note that as a member of the Hate Crimes Working Group, we fully endorse both their written and oral submission on the bill. And in addition to this, the SAJBD would like to begin our presentation with a brief discussion of anti-Semitism and then focus on 4 key concerns regarding the bill that were raised in our written submission. Anti-Semitism in South Africa. Anti-Semitism constitutes prejudice against the Jewish people, whether defined as an ethnic or a religious group or both. It can also refer to prejudice against Judaism, the Jewish religion. Such acts include assault, vandalism, verbal abuse, boycott initiatives specifically aimed at South African Jews, and the dissemination of anti-Semitic literature. Anti-Semitism can also manifest under the guise of hostility to the State of Israel and/or Zionism, the Jewish nationalist movement. Anti-Zionism does not automatically amount to anti-Semitism, but in certain instances, it takes such extreme forms as to resonate strongly with traditional anti-Semitic tropes. Times of intensified conflict with Israel and its neighbors invariably see a sharp rise in anti-Semitic activity around the world. And there has been a steady upsurge in anti-Semitism globally since the beginning of the century, with many countries that have significant Jewish populations recording consistently higher numbers of attacks annually. South Africa has relatively low rates of anti-Semitism, with about 60 incidences recorded each year, and these mainly take the form of verbal abuse and hate mail. Even in South Africa, there has been an upward trend in the number of incidences recorded annually since 2000. Social media provides a platform for the propagation of hate speech and enables perpetrators to publish offensive material anonymously. A number of highly inflammatory attacks against the Jewish community, including incitement to violence, have been propagated on Facebook and on Twitter. I would now like to highlight 4 key points from our written submission on the bill. Resourcing. The success of the legislation in achieving its purpose is heavily reliant on the effectiveness of statutory bodies whose purpose is to address issues of discrimination. Currently, these institutions are severely under-resourced in terms of qualified personnel available to deal with the volume of complaints. This has resulted in long waiting periods between the submission of a complaint and its resolution. 2 examples of overly prolonged matters before the South African Human Rights Commission are Bongani Masuku. In March 2009, the Jewish Board of Deputies launched a complaint of hate speech against the then COSATU spokesperson Bongani Masuku. Although the Human Rights Commission issued its ruling in December of that year, it took successive cases before the Equality Court, the Supreme Court of Appeal, and finally the Constitutional Court before a ruling was enforced in February 2022, nearly 13 years later. And then there was the Tony Ehrenreich case, which is on my slide, which took 6 years. In order for the bill to be effective in combating hate crimes, the Human Rights Commission, quality courts, and other regulatory authorities must be sufficiently resourced to enable complaints to be dealt with timeously and efficiently. The possibility of retired judges being brought in on a pro bono basis might be explored. Education and training. The experience of the SAJBD is that there is a serious lack of understanding about what constitutes a hate crime and the appropriate response to this. This is especially apparent when it comes to ordinary law enforcement officials, but it is also evident in the courts. And from this, we feel that it's important that all law enforcement and judicial officials need to be given training regarding what constitutes a hate crime and how to deal with it appropriately. Citizen empowerment and education. In practice, it is very difficult for the average South African to address their grievance through the existing system, since the processes are so time-consuming, complex, and prohibitively expensive. It is also important to educate the wider community about their rights and how they can seek practical remedies through the public institutions and resources that are available. The relevant institutions must be adequately staffed, and procedures need to be in place that expedite the adjudication process. Restorative justice, education, acculturation, and sensitivity training. A challenge in South Africa is to foster a culture of respect for difference at all levels in society, with a particular focus on the youth. Restorative justice methods are essential in addressing and preventing instances of hate. Educational workshops not only address the motivation behind discrimination, but can also be used as an effective form of restorative justice. And the Jewish Board of Deputies would like to recommend strengthening and expanding current restorative justice and educational programs in the country. An example of this kind of work are the programs done by the South African Holocaust and Genocide Foundation in their 3 centers in Cape Town, Durban, and Johannesburg. I would like to share 2 examples from my organization, if I may. The first is from 2015, when the then chairperson of the Student Representative Council of the University of Witwatersrand made a number of anti-Semitic comments on social media and on the radio, including "I love Hitler" and calling Jewish community leaders devils with uncircumcised hearts. The South African Human Rights Commission failed to take action despite constant follow-up, but in 2020, the SAJBD met with Dlamini at the Durban Holocaust and Genocide Center. And it is our belief that this engagement, mediated by the Human Rights Commission, transformed someone who was an enemy of the community into a friend and ally. A second example is that of the Sneakerheads group in 2018, where the board laid criminal charges against 2 Johannesburg men in response to the anti-Semitic comments in a WhatsApp group. Following a meaningful engagement with our organization, the charges were ultimately withdrawn and an unequivocal written apology was made. The 2 men expressed sincere regret and attended a program at the Johannesburg Holocaust and Genocide Center to learn more about fighting intolerance and bigotry. And the meeting was incredibly moving for everyone concerned. The administrator of the WhatsApp group remarked on what a positive difference it had made in the conflict between people to simply meet face to face. They were able to connect with each other as South Africans and to break down stereotypes. And we feel that we need more of this in our country. In conclusion, hate crimes and hate speech are not reconcilable with the democratic principles of human rights for all as envisioned in our Constitution and our Bill of Rights. The consequences of hate crimes and hate speech are far-reaching, and the Jewish Board of Deputies hopes that this bill is passed very soon. An effective and comprehensive hate crimes and hate speech bill would send a strong message to society that any form of prejudice is unacceptable. It would also assist the police and prosecutors in investigating, charging, and prosecuting hate crimes and hate speech. It would give the courts meaningful sentencing guidelines, and it would allow for the effective recording of data so that we can better understand the nature and scope of the problem and create successful interventions. History has taught that what often ends in genocide and crimes against humanity often begins with words and isolated hateful incidences. Essential to combating hate is the need to support and expand initiatives on tolerance so that South Africa can truly be a nation where diversity is embraced. Thank you very much.
Thank you very much, Ms. Baranov, for your presentation. Honourable members. Okay, Honourable Mikolakis, do you have a question for clarity? Please continue.
Thank you very much.
Yes, Honourable Mikolakis.
Shalom, Alana. I have a few questions just based on what you presented. The first one is, you did show a few examples of where such hate crimes and hate speech was successfully prosecuted, although it took very, very long. My question to you would be that if these crimes were already successfully prosecuted, is the answer in dealing with the problem not perhaps in making the criminal justice system a bit more effective, rather than to add more legislation that could cause further confusion? Is it not perhaps that the problem lies with how effectively the police and the criminal justice system deal with these matters? It's also a similar example to, you showed some examples where people made anti-Semitic comments, and then you also showed how it was mediated and very successfully, which is very wonderful to see. But again, my question is then, is the answer more law, or would it not be that it should also very seriously be addressed as a social issue instead, that our law is currently sufficient, but that it is a very serious social issue that also needs to be addressed? With only the law, it's not going to necessarily be solved. And then my last question to you would be with regards to the comment that you made to say that the legislation would give the courts meaningful sentencing guidelines. Now, the initial draft was the sanctions in the initial draft was a maximum of 3 years imprisonment for a first offence, and then it was increased by the National Assembly to 8 years. And I would like to hear your comments on specifically when you say it will give them meaningful sentencing guidelines, your comments on the harshness or not of an 8-year prison term, possibly, for some of the crimes. And I'm now not referring specifically to hate crimes, but perhaps more that incites serious violence, but hate speech, for example, as well. What would your comments be on a maximum sentence of 8 years? The reason why I'm asking you is because some of the people who will be presenting to us will definitely argue that that is too harsh, and that we should perhaps look at going back to the 3 years maximum that was initially proposed by the Department of Justice. Now, I would very much like to hear your views on that. Thank you very much, Chair.
Thank you very much, Honourable Mikolakis. Honourable Dodovo.
Thank you very much, Chair. Just 2 points. Firstly, in March, when the National Assembly passed the hate crime and hate speech bill, you welcomed it very, very much so, that it was passed by the National Assembly. Do you still stand by that, or do you think that there are areas that are not sufficiently covered that we need to consider? If they are there, can you just spell them out? Secondly, Chair, I'm not sure whether I did hear you properly when you were talking about the anti-Semitism tendency versus the hatred against the Jewish. And if I heard it correct, you said there is a difference between the two. If that is the case, can you just elaborate on that? Or if you can't do it now, can you just, as part of the definition clarification, just send that information to us so that we look at that as well? Thank you, Chair.
Thank you very much, Honorable Dodobu. Honorable Moimang. Oh, yes,
Thank
Honorable
you.
Moimang.
Thank you, Chair. Let me start by appreciating the presentation from Alana Poo. Just two areas from myself. The ongoing prejudice in our society based on hate crimes and hate speech, despite the presence of the Bill of Rights, has been a cause for concern to mostly peaceful and democratic living South Africans. The question that I want to pose to you is whether from the body itself, are they happy that the bill, because of its origins from the Bill of Rights, present a step in the right direction in the form of a comprehensive framework for preventing and combating hate crimes and hate speech? Thank you.
Thank you very much, Honorable Moima. Okay, I see Ms. Chakapava, your hand is up, but maybe I should just indicate to you that when we're done with this presentation, we'll then come back to you. I'm sorry you lost connectivity, but we realize that there is a problem. I just hope it's sorted. But let me hand over to yourself, Ms. Baranov, to perhaps give some of the responses where you can. Ms.
Thank you so much, Chair. Can you hear me okay? Apologies, can you hear me?
Ms. Baranov, you may go ahead. I'm just waiting on the chairperson to come back.
Oh, apologies. I wasn't sure if the problem was on my side. I hope you can hear me okay.
Can hear
Yes,
you.
we can.
Oh, great. Sorry. Thank you. Just to say, overall, maybe speaking to the second question and the fourth question, and thank you so much for those questions. Yes, the Jewish Board of Deputies welcomed the bill, and we really do welcome the bill. And we are, as I said in my presentation, really looking forward to seeing it passed very, very soon. We have been engaging on the bill since it was first published. And as I've mentioned, we've been working with the Hate Crimes Working Group, advocating around hate crimes legislation for over a decade. So we really feel that it is something overdue, and we look forward to it progressing through the various systems and protocols that it needs to go through. We, in our written submission, we're clear that whilst there are certain areas that we might have input on or slight disagreements, in general, we are happy with the bill. We really want to focus on the positive aspects of the bill and to congratulate Parliament and the Department of Justice on this bill. And as I said, really see that it comes forward as the situation for particularly foreign nationals in our country facing horrific xenophobia and the persecution of the LGBTIQA+ community is only on the increase, and the violence and the discrimination that they are facing is incredibly serious. So we do feel that this bill will save lives, and it's important for it to move forward. In terms of the first question, I would just say that, yes, we do have existing legislation that tackles discrimination on the books, but we do feel that this proposed bill would strengthen that and enhance it. It adds to the existing legislation, and very importantly, we hope that it will address the implementation and the capacity aspect. Again, as I detailed in my presentation, there are pathways to address instances of discrimination and hate, such as PAPUDA, the Equality Courts, the South African Human Rights Commission, who do amazing work. And we have had successes, but it's taken many, many years of engaging with these bodies, a lot of time and a lot of money to be able to pay for the legal experts that would assist us. And we feel that this is really out of reach for the ordinary South African and people who live in this country. So it needs to be addressed, and the current structures and bodies need to be capacitated. And we also feel that there needs to be a comprehensive look at education and awareness around hate crimes and hate speech. And that was the restorative justice aspect that I was alluding to, that it's so important for us to not only have strong laws on the books, but for us to be engaging with society, changing hearts and minds when it comes to issues of bigotry and intolerance, and particularly to focus on the youth. And we see that current programs around diversity training, tolerance education workshops have been very successful. And these just need the funding and the resources to be strengthened and to be rolled out across the country. And we really do feel that that would make a huge difference. Thank you.
Okay, thank you very much, Ms. Baranov. I hope you can hear me now.
Yes, I can. Thank you.
You can. Okay. No, thank you very much. For a while, there was something wrong with my network as well, and then I got kicked off the platform. But thank you very much for your inputs and for participating in this process and responding to members' questions. Thank you, ma'am. Our members, we'll move back to the question. I think I need your guidance now. Whether Ms. Chakapfava is on the platform and she would want to finish her input.
I believe she's ready, Chairperson.
She is, no? Okay, Ms. Chakapfava, are you on the platform? I think she might be having some challenges. Okay, members, if she's not on the platform, Gershwin, I'm proposing, members, that Gershwin follow up once again with her, but then we then allow Mr. Nikki van der Westhuizen from NBCFC to then make his presentation. I think he did say that he would be ready. Okay, I see someone's on the platform.
Hi, Honourable Chairperson. Yes, he is ready. So we will be going now in the next, as I say, 30 seconds, and then we can do our presentation if that's okay.
Sure.
That's perfect. Thank you.
Okay. Gershon, while they're getting ready, is Dr. Sipho Mahlangu as well on the platform? From the next presentation? Okay.
Chairperson, I believe Professor Madonsela would be next after.
Oh, yes. Okay, sorry. No, thanks for correcting me. Right, okay. All right. Dr. van der Westhuizen, are we ready to go? I have Professor Madonsela on the platform as well.
I am here, Chair.
Yeah, my apologies for the confusion. We've there's been some network issues, so we've lost one presenter. But okay. I know I've missed you by mistake. Apologies for that. And I went on to the NBCFC. But Professor Madonsela, given that you're on board, you're on the platform, perhaps we should allow you to continue with your presentation. We'll be giving you at least 15 minutes to make your presentation. And yes, please continue. And I think Dr. van der Westhuizen, please bear with me. My apologies for that. Professor Madonsela?
Thank you, Chair. Oh, that's a bit dark. That's the best I can do. Oh, just a moment, Chair. I can do something. Honorable Chair, the first thing is just to thank you and the honorable members for the privilege to present on behalf of the Center for Social Justice at Stellenbosch University, and to congratulate Parliament for finally taking this process forward. It's long overdue. I personally was involved in drafting the Equality Act under the strict supervision of President Nelson Mandela himself. It was finally concluded in 2000. And unfortunately, parts of it remain outstanding. And as a result, our country continues to suffer disproportionately from the legacy of our past, which would still be with us. But had we implemented Chapter 5 of the Equality Act and the hate speech laws, we probably would be suffering less of the challenges that the country suffers from. I'm trying to share, Chairperson. It's not allowing me to share my presentation. It says I'm disabled from sharing.
Okay, my apologies about that. I'll just request Gershon, are you able to give Professor Madonsela those rights?
My sincere apologies, Chairperson. I disabled it so that we don't get unwanted presentations, but I've given her rights now, Chairperson.
Thank
Okay,
you.
Prof Madonsela, I'm sure you're able to do it now.
Thank you, ma'am. Now I seem to have lost the presentation. Well, whilst I'm looking for it, Chair, just to say that I come from the Center for Social Justice, and we share your concerns about advancing equality. And we believe that the constitutional duty to advance equality is twofold. One is not to cause inequality or discriminate. The second part is to end existing disparities. And this comes from jurisprudence from cases such as Barnard, which we did cite in the presentation that we sent to you. And it also comes from cases such as Grootboom, which says when we adopted this constitution, we chose to establish a new democracy that is founded on social justice, democratic values, and fundamental human rights. And of course, we are a little bit behind on those matters, including this bill, but it's heartening for us who are involved in assisting government and society to achieve social justice to see these measures being adopted, because we believe that as long as there's injustice somewhere, there can't be sustainable peace anywhere. I am seriously struggling to find my presentation, which has never happened. Okay. I really do not know why this presentation. Let me just continue to say we support firstly the bill. We think that in broad terms, it complies with the requirements of instruments, international human rights instruments that impose obligations on member states to prohibit and end hate crimes and hate speech. Key among those being Article 4 of the International Convention on the Elimination of all forms of discrimination, of all forms of racial discrimination. Our own constitution also says that we're adopting it in order to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. What that means is that the prevalence of odious practices such as hate speech, which was sanctioned by law in the past or ignored by law in the past, should not be part of our transformed society. Indeed, in Grootboom, the Constitutional Court said, the people of South Africa are committed to the attainment of social justice and the improvement of the quality of life of everyone. The preamble to our Constitution records this commitment. The Constitution declares the founding values of our society to be human dignity, the advancement of equality, and the advancement of human rights. Just very broadly, our understanding of social justice is that it is justice that refers to a state of equal enjoyment of all rights and freedoms, which is reflected in just, equitable, and fair distribution of all opportunities, resources, benefits, privileges, and burdens in a society and between societies. This definition is based on the plasticity of the concept of social justice, since it was coined by Luigi Tapparelli between 1840 and 1843, and elaborated on by Antonio Rosmini, who brought it into law in the Constitution from 1847. It was adopted by global leaders as part of the Treaty of Versailles in 1919. And relevant to our context today, it was integrated in the International Convention on the Elimination of All Forms of Racial Discrimination, ICED, in 1963. And then it has since been developed primarily by our Constitutional Court in cases such as Makwanyane, Grootboom, Van Heerden, etc. So in our assessing this bill, we are assessing it from the point of view of the extent to which it is anchored in constitutional fidelity regarding the advancements of social justice. And you would say inside the Constitution, social justice is not mentioned, but clearly in Makwanyane, we are told that the whole Bill of Rights is infused with social justice, because if we agree that social justice is equal enjoyment of all rights and freedoms, therefore social justice entails that everyone should be equally entitled to the full menu of rights that are promised in the Constitution. And when others are not experiencing those rights in equality with others, then we are experiencing social injustice. And hate speech, you must agree with me with the fact that it does undermine equal enjoyment of various rights and freedoms. Key among the rights it undermines is the right to human dignity. But above all, there's a correlation between hate speech and hate crimes. In the written submission, we show the correlation between the prevalence of hate speech and crimes such as genocide, the Holocaust, etc. In our country, we can think about how hate speech justified practices such as slavery, racism, etc. And in modern South Africa, hate thinking, which obviously is given legitimacy through hate speech, influences those who commit crimes against the LGBTQI community. Again, in our submission, we mentioned the case of Gugu Dlamini, among others. We mentioned Nazi Germany, Rwanda. And David Livingstone, Professor David Livingstone Smith says, when we dehumanize others, we banish them from the magic circle of moral consideration. As a consequence, inhibitions against harming them are thereby disabled, and we feel free to dispose of them to suit our purposes. So this is where then you see an intersection between hate speech and other hate crimes. Once we persistently dehumanize others, once we persistently vilify others, we invite others to harm them, but we also give ourselves permission. We release ourselves from the moral obligation to treat others as human. In other words, we fall short of the standard the Constitutional Court said our democracy is based on when it said Ubuntu. The concept of Ubuntu is one of our foundations, of our foundational considerations. And Langa explained very clearly that within Ubuntu is respecting the equal worth of every person. I then move to our analysis of the bill. Firstly, we find that the bill appropriately references the Constitution and international normative standards regarding the prevention and protection of society from hate crimes and speech, to the extent that it prohibits acts and speech that harm or incite harm on prohibited grounds, what the UN refers to as identity factors. It conforms to Section 16 of the Constitution, which prohibits advocacy of hatred based on specified grounds and speech that constitutes incitement to cause harm. Here are some of the concerns we have, honorable members. One is the preamble references primarily the race parts of our international obligations and normative standards. And of course, that does make sense given the fact that apartheid was declared by the United Nations a crime against humanity. However, from a social justice lens, which is a multifocal lens on embracing the humanity of everyone, then the bill falls short. If we agree with the Constitutional Court that we have adopted social justice as a definer of our relationships as a society, then the bill is a bit narrow, at least in the preamble only, insofar as it only emphasizes race. And in that context, the bill needs to extend itself to deal with gender, LGBTQI, and other forms of exclusion, vilification, and harm. In the body of the bill, it doesn't limit itself to race. It deals with all of these other grounds, including intersection of grounds. Two, the bill is appropriately grounded in applicable constitutional obligations on hate speech, a key being Section 16, Section 9, Section 7, which is very important because government has a duty to protect human rights, advance human rights, and ensure that these human rights are recognized and achieved for all. And if you take that with Section 237, then it's very clear that government has a duty to prioritize this matter because it's a constitutional obligation. Three, when defined in a limited way, that excludes other harms might be problematic. So I see others are complaining that the definition of harm is vague. I would rather it stays as expansive as possible, which leaves room for the courts to give content to it. And I take the cue from Kwelane, where the Constitutional Court was not happy with Section 10 of the Equality Act, which I led the process of drafting by saying that it was a little bit confined. 4, Clause 4.1 excludes analogous grounds. You will see in Section 9 of the Constitution, there are defined grounds, which are about 16 or so, and then it also mentions grounds that have a similar impact as these ones. Our reading of the bill as it stands is that it doesn't mention analogous grounds. 5, the bill focuses on the criminal justice system at the exclusion of restorative justice. For that reason, it is not very useful to the average Gogo Dlamini who is confronted with sexism, racism, harassment of the LGBTQI community, harassment of non-nationals, etc. Because now they've got to go to a police station, etc. We think that as suggested by our colleagues from the Jewish Board of Deputies, consideration should be given to a bifurcated approach where the victim is given an opportunity to make a decision, where do they want to go. The problem also is because our criminal justice system has never been transformed to the point of embracing a human rights culture. It's still state versus somebody. In other words, it's still assumed that when you harm a person, you've harmed the state, which comes from Rex versus somebody where you had harmed, if you had harmed a subject, you had harmed the king. And a whole lot of people in our traditional societies might even prefer to go to a chief's crawl where at least they can get a cow or some other compensation as restorative justice when they have been harmed or their dignity has been harmed. So we're just asking that consideration be given to an alternative to how you would like to vindicate your rights. 6, the penalties under Article 6 may be disparatively expensive for ordinary members of religious groups. What I didn't indicate, which we indicate in the submission and here in the slide, is that we're judging this bill based on an instrument that we've designed at Stellenbosch University to assist you lawmakers to prospectively assess the impact of the laws you draft on different groups in society, so that you can tell whether there'll be disproportionate harm to some social groups and disproportionate benefit to some groups. And this instrument is called the Social Justice Impact Assessment Matrix. So it asks you 9 simple questions. The first set of questions is about what are the constitutional objectives that inform the bill or policy or program you're about to draft, and is there congruence between those objectives? We find that there is congruence between what you're trying to do here and the constitutional obligation. But the second one is you need to clarify your target beneficiary. And to do so, you need disaggregated data. If you don't clarify your targeted beneficiary, you do what in the past we used to talk about, men size fits all, when laws are designed primarily to suit men, and then women have to try to fit in. And some call it one size fits all. Our own assessment, though, is that we, the elite, we tailor laws to fit our lifestyles, and therefore it's our size fits all. Unfortunately, the people in diverse settings in society have to just fall in or fall out. And it's not intention, it's just the need to use disaggregated data to clarify your target beneficiary. And we think that bill has great intentions, but it's not going to benefit the average Gogo Dlamini, simply because of the need to have enforcement mechanisms that are accessible to the average person. And to the extent necessarily, it would have to differentiate, and this is where colleagues from the religious community are talking that there might be a disproportionate sanctions. I mean, if the sanctions are against the whole church, it means something, but if you're dealing with ordinary members, it might be disproportionate. You need to make sure that no group gets inequitable advantages or privileges. 6 is important to us that it has to have a restitutive element. The bill has, and this is where the sanctions may not be restitutive, because if somebody has insulted you, why would you want to subject yourself to torture so that government can benefit from fines or somebody could go to jail? You would want to be restored as close as possible to where you would have been, but for the harm. And for example, the harm might be mental health challenges that you have suffered because of the harm you have been subjected to. And therefore, that's where restorative justice is important. The next one is avoidable harm, is that we should be ensure that our policies are not just proficient, but also they are proportional, in that we don't use a sledgehammer to kill a fly. And this is where we might need to differentiate between individuals and institutions. And the question of making sure, the next one is about making sure that in the event some group will be disproportionately impacted by the regulation that we're introducing, we then need to have a mitigation strategy. Earlier on, there was a talk about meaningful engagement. I do know that Parliament tries a lot to engage all of us, but consideration needs to be made to how do we meaningfully engage the Gogo Dlaminis as well. Because not only is this bill going to help vindicate their rights, but it's also going to impose criminality on every human being. And they need to know through the process of engagement that this is coming. Because consultations on law is beautiful not only because it helps people to define the laws that will regulate their lives, but it also becomes a teaching moment. If you've been involved in the drafting of the law, as people were involved in the drafting of the Equality Act, then you are able to take advantage of that law. In conclusion, honorable members and colleagues, the Center for Social Justice at Stellenbosch University supports the spirit of the bill and considers it to be in line with the country's duty in terms of international human rights normative standards prohibiting hate crimes and speech. For example, Article 4 of ICED. It's also in line with the constitutional commitment on social justice, which is in the preamble, and constitutional duty, and the constitutional equality duty in Section 9, read with Section 7, the preamble, and 237 of the Constitution. But there are 3 recommendations that we're making. One is it needs to be reviewed to ensure better fidelity to constitutional dictates regarding substantive equal enjoyment of the rights it confers regarding the protection from hate crimes and hate speech. And key to our recommendation is restorative justice as an option. And then 3, recommends some improvements in the balance between freedoms, particularly freedom of speech, and the state's duty to protect those who are subjected to hate crimes, including hate speech. So this is particularly in the area of religion, that the idea is nobody has a constitutional right to harm others. But in so ensuring that nobody harms others in the name of free speech, we still have to leave room for human beings to be human beings. Lastly, we support the suggestion that extensive education on the contents of the bill will determine its success. I often say that the law is like an arrow. Where it lands depends on the make of the bow and the mindset and skills of the archer. You are making the laws, honorable members, but how these laws will be felt by everyone, from cleaner to president, from rural people to CEOs of companies, will depend on how those who are supposed to comply with the law will understand it, and those who will be charged with interpreting it will understand it. Thank you once again for the privilege, and it is our hope and sincere prayer that this bill will be concluded before the next election. Thank you, ma'am.
Thank you very much, Professor Madonsela, for your presentation. Honourable members, are there any questions for clarity that you would want to ask? Honourable Badenhorst.
Thank you, Chair, and thank you, Prof. Madonsela, for your insights into your submission. It's really a privilege to have listened to you again. Yeah, you and I met about 3 years ago when I attended a short course at the Stellenbosch University, and I was privileged enough to get you to sign my copy of the Constitution, which I still have. So it's a fond memory. Prof, thank you very much. I just we've obviously received quite a few submissions, and gleaning some information from those submissions. I'd just like to get your insight, if I may. You've referred to clause 4.1a and the definition, the 2 elements that are very important, the element of harm and the element of hatred. And you referred, I just want to take you to the element of hatred first. The one submission we received points out that this bill doesn't actually define hatred or hate. And that might be problematic in the sense that it leaves it to Parliament then to basically abdicate its responsibility to the courts to go and define what hatred is. I would like to get your insight into the absence of that definition in this bill, and if you would venture then to define it for us if you want to. And then to go back to the first element that you referred to, and you referred to the Kwelani case. Now, the Kwelani case was a civil matter, and this act establishes a criminal act. So should the definition in the latter then follow on the former? I'd just like to get your thoughts on that as well, please. Thank you so much for your submission. Much appreciated.
Thank you very much, Honorable Barnard. Honorable Mikolakis.
Thank you very much, Chair. Good afternoon, Professor. Yes, Chair, I have a few questions. The first one is, I noted that Professor Madonsela indicated that she would like the definition of harm to be as broad as possible, and then for the courts to lend meaning to it. But according to, or in her opinion, what then should be the objectivity test when it comes to measuring what harm is? Also, with regards to hate, I do see that she has in her submission made mention of a definition of hate that was used elsewhere. Would she recommend that that concept be defined in a similar way in the bill? Because we are currently lacking a clear and proper definition of what hate is, and it does bother me very much when you have a criminal offense, but all the elements are not clearly and properly defined in the legislation. Then also, the definition of harm, as it currently is in the bill, also includes social and economic detriment. And I would like to hear her opinion on whether these two elements are necessary to be included, specifically the economic detriment, but I also have some concerns with regards to social detriment because it is not clearly defined. So some would argue that, for example, and I would like her opinion on this, for example, criticism towards the governing party might cause social detriment if it's a strong freedom movement or what have you. What would her response be to objections along those lines? Then, Chairperson, with regards to specifically Section 4, Subsection 2, it does cover people who do something in good faith based on artistic expression and faith. But it does not currently cover people who share those specific elements or sentiments. So, for example, if there is a specific work of art that might be excluded by the bill due to that clause, I don't currently see that in the form that it is, it covers those who, for example, perhaps share it on Facebook, and so it only covers the artist or the person uttering the words. Would that not be perhaps a bit problematic? And also, to a great extent, the latter part of clause or of Section 4, Subsection 2 is to a great extent self-defeating, because you exclude persons on those grounds, and then particularly mention that except where they make themselves guilty of the initial thing that they are exempted from. It to some extent is, in my opinion, very much self-defeating. Another question that I have, and I do apologize, Professor, but I would very much like your opinion on most of these aspects. The 8 years maximum sentence for a first offence, in the initial bill that was brought to Parliament, as I've said earlier, it was 3 years. It was the National Assembly that moved it up to 8 years, which some might argue is, and I tend to agree with them currently, that it is extremely high. What would your opinion be on such a high sentence for a first offence, specifically with regards to lesser crimes or lesser forms of the crime, and taking in consideration that we need to look at alternative measures of sanctions? And then finally, Chair, my last question would be, should the definitions, as the professor said, harm should be defined as broadly as possible, but should the definitions, not since we're dealing with criminal law, be defined more narrowly than it is in Pepuda and in civil cases as in Kwilani, specifically because we're dealing with criminal law? Should those definitions not rather be defined more narrowly in criminal law than it currently is the case in our civil law? Thank you very much.
Honorable Dado.
Thank you very much, Honorable Chair. Professor Madonsela has given us a lot of takeaways, issues that are extremely important that I believe we need to really take into consideration. Now, some few issues. I was carefully listening to her when her proposals. She says, I support the spirit of this legislation. I was really waiting for her to say, I also support the letter of this bill. And I would want to check with her, why didn't he say that, and why didn't he elaborate specifically what she supports in relation to the letter? Because if it is the spirit and the letter, it helps, especially from a person of her caliber, in respect of her articulations and what she has given to us. Secondly, I follow on what Honorable Mikalakis is asking. Obviously, these hate crimes, hate speeches are not the same. It can be, as she's saying, one size fits all. There are those that are harsh, there are those that are extreme, there are those that are less, and I concur. 8 years, especially for first-time offenders, is a bit harsh. What is her view on that? I really want to underscore that point, so that I want to solicit her opinion in respect of that. Now, in terms of justice, she mentioned 2 ways of resolving the issue itself. And the first one was retributive justice, where in which there is punishment, and I think I've addressed that. But the second one was restorative justice, where there is, in one way, a reconciliation or a mediation between the victim and the offender. I've not heard talking about the third leg of justice, that is redistributive justice, in which, in order to address especially the legacies of the past, you take something from those who are well off, those who are high class, who are opulent in the society, and support those who are in need. I have not heard a comment on that. If she can comment on that, it will help me as we take the process forward. Other than that, as I said, Honorable Chair, this was a real takeaway to take for consideration. Thank you very much.
Thank you very much, Honorable Dodogo. Honorable Moimang.
Thank you, thank you, Chair. Also allow me to also express a positive appreciation for the presentation made by the Prof. Just one question from my side, Chair. Whether the bill go far enough, will it go far enough to address, to strike a balance between the freedom of the need to practice your religion, but at the same time appreciating the law, the law in terms of protecting the victims of discrimination, whether it's based on intersex and sexual orientation, particularly where some of the religious bodies will openly declare that their stance against non-heterosexism. I'm raising this point, Chair, informed by the definition that is given in Section 3, which clearly articulates what hate crime is, particularly its reference to motivation based on prejudice and intolerance towards a particular victim. But not only that, but also, like as you have correctly pointed out, the listed grounds that articulates what could constitute a hate crime, but also taking into account the clarity of thought that was given by a Galani judgment in terms of what constitutes hate speech. But not only that, but also given the fact that Section 4 also then give more elaboration in terms of what will hate speech include, which goes to an extent also of including intentionally publishing, propagating, or advocating anything that could reasonably be contributed to demonstrate the clear intention to be harmful or to incite harm. Thank you, Chair. Thank you, Prof.
Thank you very much, Honorable Moimang. I think, Prof, there has been quite a few questions that have been asked to yourself. I mean, I would hope that you would be able to respond to some of them, and if you feel that you need time, maybe to give it to us in writing, I think that will also be very much appreciated. Yeah, and I think what the standard we're using is that if you could get it by in a week's time, that would be by next week Tuesday. But please feel free to respond to what you can. Prof, over to you.
Thank you, Honorable Chair. I really appreciate the privilege to consider a supplementary response in writing. Thank you to honorable members for the kind compliments and questions. Regarding the definition of hate speech, the United Nations Strategy and Plan on Hate Speech defines hate speech as any kind of communication in speech, writing, or behavior that attacks or uses pejorative or discriminatory language in reference to a person or group on the basis of who they are. In other words, based on their religion, ethnicity, nationality, race, color, descent, gender, or other identity factors. So the key things are communication, and it could be anything, any kind of communication, including a cartoon. It could, and it should be in writing or behavior, which it should have an element of attacking. It should have a pejorative element and discriminatory language. In our own jurisprudence, there's a huge emphasis on the infringement of human dignity. So and then the other question was hate crime. My understanding is that a hate crime, as defined in the Equality Act, would be an ordinary crime that is committed with an additional motive of hatred and discrimination against that group. For example, the killing of women that is inspired by misogyny would be a hate crime. Killing of somebody, the killing of Gugu Dlamini that I mentioned to earlier would be a hate crime, because murder is a crime on its own, but being killed because you are lesbian brings in the hate part of it. And Honorable Michaelakis wanted to know whether we could distinguish between hate speech in criminal proceedings and hate speech in civil proceedings. I don't think so, sir. I think it would be just a burden of proof, but not a distinction in definitions. It would be very confusing to say this hate speech is okay if it's a civil matter, and this hate speech is not okay if it's a criminal matter. I do understand where this comes from, and it comes from what Honorable Dodovo and Honorable Mayema has brought to the fore, which is how do we balance some of the freedoms that people have from the same constitution with the state's duty to protect everyone from hate speech and crimes. And the very difficult one being religion, especially as practiced by ordinary people. And that takes me to answer the question from Honorable Michaelakis on the 8 years maximum sentence. For me, I don't think it's heavy, because you're looking at maximum. You're not saying everyone who commits a hate crime of a speech nature will get the maximum sentence. What I probably did not highlight in my presentation today, but which is in our presentation, is that there's no distinction in our brain between being hit with an object and feeling pain and being hit with words. In fact, we start with the presentation where I mentioned the fact that Swazis knew this all the time when they would complain about the fact that the Zulus beat them very thoroughly, but they did insult them very thoroughly too, which means Swazis and Scottish people knew that insulting people had a similar impact on the brain. But on a much more serious note now, neuroscientists show that when somebody repeatedly insults you, the brain suffers the same kind of pain as you suffer if you are being hit with physical force. And therefore, we can't take hate speech lightly. But of course, the court, or at least the Department of Justice, might come up with a list of indicators in terms of the spectrum of these crimes. We must also understand that already hate speech is prohibited in terms of Section 10 of the Equality Act. It's just a question of the Golani case having cautioned around a confined definition that seems to narrow the parameters from Section 16 of the Constitution. So I'm sorry, I would answer no for now, but we're going to look into it further and maybe again go back to jurisprudence in countries such as India and Canada and the United Nations guidelines, particularly the action plan that has been issued by the United Nations. And then there was the question of the remedies. I think Honorable Dr. Odufu asked me if the remedies might not be, that we're proposing might not favor the rich. I suspect because rich people can pay fines, we can be creative about remedies in such a way that they can be linked to people's income. In fact, if we're looking at substantive equality, our fine system is not fine, because 10,000 Rand is nothing to somebody with an income of 200 million a year, but 10,000 Rand is everything to somebody with an income of 10,000 in 5 months, or even less than that. So I think our fine system also needs to be reviewed to be commensurate with people's incomes. And then maybe I'll answer this last one, and then the rest will submit in writing, is if I support the spirit of the bill, does it mean I don't support the letter? I support both the spirit and letter of the bill. However, when it comes to the letter, honorable members, we have indicated as the Center for Social Justice that would like it to be tweaked a bit. Number one, the issue of access to justice. We are saying that the majority of ordinary people, number one, would benefit nothing from the criminal justice system. And number two, will find it difficult to access these measures that have been provided. And I'll give you an example of a place called Emanzimeleni, where the Tuma Foundation has been doing some work on sustainable development goals. They don't have a local police station. And the last time I was there, they had 54 murders that had been reported and none of them had been solved. So they're not likely to rush to the police station to report when they have been harassed as gay or as female or as an older person or as a non-national, etc. So if we want these remedies to work in preventing and combating hate crimes and hate speech, then number one, they should have a teaching impact on would-be offenders. But secondly, they should have real remedies, real accessible measures for vindicating rights for potential victims. Thank you, honorable members. Again, we do think it's a wonderful initiative, and we hope that it will be concluded before Parliament closes. Thank you.
Thank you very much, Professor Madonsela, for your inputs and insights on this bill. We look forward to your supplementary responses as well, and preferably we can get it by next week, Thursday. Thank you very much, ma'am.
Thank you. Thank you.
Our members, we need to go on to the next presenter, but Gershwin, I don't see them on the platform. Gershwin?
Yes, Chair, they seem to have gone off again.
Okay.
I'll
All
try and
right.
get hold of them.
Our members, okay. Can I propose that we take a 5-minute break on members, a leg stretching? It's 5 to 4, and we can resume at 1600 hours. If that's okay with you, honourable members.
It's okay, Honorable Chair. How many presentations to go for today?
We just have 2 more plus Little Labantu. Actually 3 more. But Little Labantu seems to be having some challenges, looks like it, and I doubt they'll come on board. But I think Gershwin will make the necessary follow-ups with them. And then we just have two left, if not that.
Chairperson.
Mikolakis?
I just want to ask you, we didn't foresee, I believe we'll be done by then, but I did not foresee that we might still have 3 left by this hour. I just want to ask if it's possible. The program did say we'll carry on until 4:30. I have made arrangements for my further meetings at around 5 o'clock. If it is possible for us to be finished for today and carry on tomorrow by 5 o'clock, I'd be very, very grateful. I don't want to miss the opportunity to engage with any of the stakeholders. And if that would at all be possible for whatever is not dealt with by 5 to stand over, I'd really, really appreciate that. Not to miss the opportunity to engage with them. Thank you.
It's fine, Honorable Mikolakis. Let's just see how we proceed. Okay, so we left with 3 minutes of a break, honorable members. So we cut the 2 minutes out because of our discussion. So if we can just take a 3-minute break, and Gershwin, can you get the NBCFC, if they are ready, if they need to flag anything, let them do it, whatever, so that when we get back at 1600 hours, we just go straight into their presentation. Sure. Honourable members, I hope everyone's back on the platform. Okay, Dr. Nikki van der Westhuizen, we're back with you again. I hope you're ready this time.
Yeah. Well, good afternoon, Honourable Chairperson and everyone on this platform. Thank you so much for allowing us to speak as well and be part of this. For the past couple of minutes, hours, I've been listening to, all the viewpoints and where we're coming from. And, for me, I've already submitted all the definitions and the things that we feel as a religious or Christian faith, where we can, we have to bring definition and clear understanding on this matter of hate speech and the hate crimes. And I don't really want to go back into that because a lot has been said. I just think from the perspective that I want to come from, representing, the Christian faith, various organizations, I'm very concerned about, just the definitions that must be clearly defined. If we miss this thing now, it's not just about us here. It's not just about me and you and everybody on this platform. There's a generation waiting for us. In 50 years from now, I'm not going to be here, but the law might still stand and the bills might be passed. And we have a generation coming up. We have people coming up. We have a legacy to leave. And I think we have allowed so much already to take place. If I just look in our country of things that we have just allowed to go past, and we've just accepted it. And eventually this thing is catching up onto us as a generation. And my concern is the next generation. What are we putting in place for them? How are we going to define this? How are we going to bring proper education to them? Defining these matters, clearly explaining to them how we're going to do this. And we as a country has come so far. And by getting everybody on the same page, this is not about, with all due respect, it's not about a group, a religion, a mindset. It's about everybody working together in this nation of us to come to a place where we all understand. And for me, that is the biggest thing today, is as Christians, how will this affect our Christianity in the future? How will this affect our faith in the future? And also for me as a minister of the gospel, how does it affect me in helping people that's going through trauma, going through physical abuse, through all these things? Because if you give counsel as a registered counselor or a doctor in certain things, and you give counsel and that person gets offended in that counseling session where you try to be helpful and understanding, they can turn that thing around and send you to prison, So honestly, for me, the platform that we have here is so good because we can listen to everybody and we can understand everybody's viewpoints. My biggest thing is just, where do we as ministers of the faith get the understanding? What is the clear definition of hate speech, hate crime, that we can help people. It's all about helping people. It's all about bringing the best out of people. Everybody has a purpose and everybody has a destiny, and to help them reach that place in guidelines and bring clear understanding. That's, I think, from my side, representing churches and generations and a lot of entrepreneurs and business people. I feel there needs to come that clear, distinct explanation on how we want to let it roll out into the generations to come. We have given 4 solutions or alternatives to this bill that I've already submitted, but and we can always go back to that. And I don't want to take time because I know everybody's in a rush and everybody wants to go out. But there are things like our doctrines, our belief systems, according to the scriptures, whether it's the Quran, whether it's the Torah, the Bible, we have to understand the lines drawn to this. And so from my side today, Christianity should be, and I know a lot of people got hurt through various religions. We understand. But Christianity should be a basis of love, reconciliation, bringing people together, helping people, lifting them up, and taking them to the place where whatever God has in store for them, to fulfill that in their lives. And for me, that is the big thing, is that we don't want to cross lines. We don't want to make it, I want to say difficult. We don't want to make it difficult for anyone, but we need to have an understanding, because Christianity is a very big religious group in our country. And I think we can pull them all together. I think we can have the same mind, same heart, same passion like Jesus had, and bring it into the hearts of the people, and bring it across in a very good manner. So that's where I want to come from. Like I said, the submissions have been made, and our time is running out very fast, and I want to give everybody else an opportunity. But just from my side is that I think we've come a long way. If we can have clear definitions of hate crime, hate speech, it will help us speak to the Christian religious world, and we can bring direction according to that. So that's from my side, Chairperson. I hope that brings some understanding as well where we come from as the Christian faith.
Thank you very much, Dr. van der Westhuizen, for that very brief input. And yes, I agree that your submission does, you have made proposals in your submission, especially around definitions relating to harm, hatred, as well as how you think clause 4-D can be strengthened. Thank you for that. Honourable members, are there any more questions for clarity to Dr. van der Westhuizen? Honourable Mikolakis?
Thank you, Chair. Thank you very much, Dr. van der Westhuizen, for your presentation. Just switch on my camera so you can see me as well. Yes, I have one or two questions. The first one is, I would like to hear your opinion on the 8 years maximum sentence for first offenders. That is a question I have asked some of the other stakeholders as well. And I intend asking all of them that same question. It is something that is bothering me quite a bit about the bill, and I'd like to hear your opinion on that. Then also with regards to clause 4, subclause 2, the exemption in certain cases. In what instance does that still, as it stands right now, still prevent you and your ministry from exercising your constitutional right to freedom of religion? And then also with regards to the bill in its totality, is your issue currently with both the hate crimes and the hate speech part, or is it mostly the hate speech part that is concerning to you at this stage? Thank you.
Thank you very much, Honourable Mikolakis. Yeah, Dr. van der Westhuizen, there's no other member who wants to ask. Oh, Honourable Dodo, before you respond, Honourable Dodo.
Honourable Chair, just a quick one. Doctor, there is a concern from other religious groups. As you know, we are a secular state. They argue that their religion is not adequately protected, and people with ease deplore hatred to such religion. An example is Jewish. They said that Muslims are also saying that. What is your view on that particular point? Do you think that the current bill as it stands has got sufficient checks and balances to cater for all religious groups, irrespective? Thank you.
Thank you very much, Honourable Dodo. Over to you, Dr. van der Westhuizen.
Thank you so much for the questions, Honorable speakers. The hate crime, here's what I want to say. I think, there exists a potential slippery slope on this thing. Because our concern is that the hate speech bill might be the beginning of a broader restriction, broader restrictions of free speech. So it starts small now, eventually it will be leading to more and more categories of speech being regulated and prohibited, including what we can preach, what we can say, what we can teach from the pulpit. Those are also, for me, a thing that I can think can become a problem in the future, For me and for us as well, the hate crime, I think, for me, is the big thing, and obviously hate speech is not right. We're supposed to lift people up, we're supposed to protect people and their rights, their emotions, everything. The hate crime is the thing that we need to bring clarity on. Let me give you an example. If I counsel a couple that comes and sits in my office, and the woman, then she's angry, or the man is angry, and they want to get a divorce, we are there to help. We are there to see if there's reconciliation. Firstly, to reconcile people. If that doesn't work, obviously we start taking the routes with the authorities in the right direction. But a lot of things are said in those meetings, obviously confidential clauses are in place and all those things. But if something goes wrong there, if I, for instance, say, you know what, sir, I think you need to apologize to your wife. I'm just using an example, and he doesn't like what I say. And he says, you're taking her side. You're now coming against me as the man of the house, because there's so many different views of a man of the house. By helping him, I can all of a sudden become the victim here and be criminalized for helping a person. That's what I'm trying to say. There must be that clear definition on how do we help people still as a minister of the gospel. How do I help people out of marital problems, out of relationship problems, children against parents, parents against children. We're working with those things the whole time. Gender-based violences, there's so much stuff that we help people with, but now you have to be careful on what you say. So you really cannot minister from a place of the spiritual life to a person to help them, because that thing can be turned around and you can end up as the person going to prison for that. So that's where my concern is how do we define this? How do we get this thing on equal ground? So I hope that answers that question. I just want, as a minister, I want to be supportive by, number one, our government, by our people, to say this is where you can go, this is what you can do, and help us and strengthen us. By doing that, we can strengthen the people as well in this matter. Yeah. Sorry,
thank you.
What about non-legislative ways to combat hate speech? Sorry, Chairperson, sorry. Are there not non-legislative ways to combat hate speech? Like education, public awareness, campaigns, social media platforms. Can't we address these root causes on platforms differently than putting crime or laws, all these things in place? Just a question, because we all have voices on these platforms. We can mobilize millions of people by doing it the right way. We don't even have to go to the legislative way, on this. It's just an idea, that I want to throw out there. Thank you, Honorable Chairperson.
Okay, thank you very much, Dr. Nikki van der Westhuizen for making your input to the committee and also for responding to some of the questions that members have asked. I must also apologize for trying to bring you on the platform, take you off, etc. My apologies for that. Yeah, I think there's just been some challenges with the network, but thank you very much for your input.
Thank you.
Okay, members, I think we'll then move on to the Ecumenical Leadership Council of South Africa. Dr. Sipho Mahlangu, I think he's been on the platform with us from the beginning. Dr. Mahlangu, welcome. And I think you know the drill by now, so I'm not going to repeat it, but essentially you have 15 minutes to speak to your written submission. Over to you.
Yes, thank you very much, and good afternoon, Honorable Chairperson, and to all the honorable members and to my colleagues. I hope I'm audible enough. You can hear me well. I represent an organization called the Ecumenical Leadership Council of South Africa. It's a non-profit organization founded as an association of ecumenical church organizations representing more than 20,000 members. But without saying much about our organization, I just want to talk on our submission that we did. But maybe before I speak much on what we've submitted, when I listened to the second speaker, I think his name was Mr. Ashraf Parker from the Association of Muslim Accountants and Lawyers. I think my presentation is parallel with what he was saying. And our written submission sought to establish that the legislation has failed to define the offense of hate speech with sufficient clarity through this proposed bill. We also want to show how the hate speech offenses provided in the bill overshoots the mark and falls outside the specific exclusion of hate speech provided for in the section 16(2) of the Constitution of the Republic of South Africa, thereby violating the right of freedom of expression. Section 16 of the Constitution, as we may know, guarantees the freedom of expression. However, Section 16(2) lists a number of instances where this right can be limited. In other words, it lists the group of instances that are not protected by the freedom of expression and reads thus. Number one, subsection 1 does not extend to the following, which is the propaganda for war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitute incitement to cause harm. We cannot, however, have a discussion about Section 16 without mentioning Section 15, which ensures religious freedom. This is because religious freedom involves both the right to believe and the right to practice that belief. Our difficult past in South Africa demonstrates that truly democratic government cannot exist without an effective freedom of expression clause. It is our opinion and submission that Section 16 goes along or a long way and is sufficient to ensure that this freedom is well maintained. While we agree that there is a need to take firm action against hate crimes, the issue of extending hate speech is significantly more complicated due to the impact that the proposed bill might have on the core right to the freedom of expression. Our painful history of hatred, bigotry, and prejudice nearly brought the country to the brink of destruction and total anarchy. Recent events in the country, for example, where individuals were killed because of their sexual orientation, have also shook the country to its core. As the council representing Ecumenical Church, We condemn hate wherever it appears and support all actions that seek to significantly reduce or eliminate the promotion of any hateful practices. This notwithstanding, our submission revolves around the fact that the proposed legislation, or any legislation for that matter, should not limit the right to freedom of expression that is carefully defined and protected under Section 16 of our Constitution. The Ecumenical Leadership Council of South Africa submits that through increasing the number of protected categories from 4, which are the race, ethnicity, gender, and religion, this bill went far beyond Section 16 clear intention. The bill increases the number of protected categories to now include a new definition of harm that includes emotional, psychological, physical, social, cultural, and or economic harm. A definition that we submit is so broad and open to subjective interpretation, meaning that if one of our affiliates delivers a sermon that offends someone's feelings and emotion, then that can be construed as harmful and therefore declared as hate speech. This threat to freedom of expression is further compounded by the possibility that any person who is convicted of an offense of hate speech is liable to a fine or to imprisonment for a period not exceeding 8 years, or to both fine and such imprisonment in some instances. The legislation establishes the offenses of hate speech and hate crimes by requiring that hatred of people due to shared characteristics be regarded as an aggravating factor in sentencing and by prescribing minimum sentences for such crimes. This is despite the fact that hatred is already being considered an aggravating factor for statutory offenses under existing common laws, such as the Righteous Assembly Act and the Criminal Injury Law. And we've seen that happening in the past in the case of Miss Vicky Mombek from KZN. Maybe some of us know about that case. We've seen these laws and acts being used. What baffles our mind is that the bill seeks to criminalize hate speech without properly defining what hate is. Our esteemed colleague Daniela Ellenbeck put it eloquently when she said, "Are we criminalizing hate speech or criminalizing the speech that people hate?" While the necessity to firmly combat hate crimes is widely agreed upon, the issue of creating a hate speech crime in general is significantly more contentious due to the potential effects that the proposed legislation may have on the fundamental right to freedom of expression. We readily concede that the bill extends a broad exemption from its provisions for any bona fide artistic, creative performance or other form of expression, any academic or scientific inquiry, fair and accurate reporting or commentary in the public interest, the bona fide interpretation of proselytizing or preaching and espousing of any religious tenet, belief, preaching, doctrine, or writing. There is a prima facie impression to the effect that religious communication is protected by the aforesaid exemptions through the clause that provides the bona fide interpretation of proselytizing or espousing of any religious tenet, belief, teaching, doctrine, or writing. However, for us, the contentious proviso accompanying this is that the expression of these religious communications, the proselytizing and interpretation, would have to take place in a religious place of worship or constitute some form of formal proselytizing in public. The issue for us here is what constitutes formal proselytizing. Does a formal proselytizing exclude a pastor or a priest who preaches the word of God in the street corner? Does it exclude a pastor who ministers in the trains, in the buses, or any form of public transportation as we see in many of our communities? Does it exclude a pastor who pitches a tent for soul-winning purpose? The truth is that if the bill passes and becomes law, a lot of religious leaders who make up the majority of our affiliates will have to cross a potentially combustible minefield in order to preach the gospel. How do religious leaders preach a biblical scripture that says, for example, homosexuality is an abomination without being labeled as hate speech or maybe facing criminal charges if the bill is passed? Section 15 reads in conjunction with Section 16, establishes the right of individuals and communities to free exercise of religion. Thus, in South Africa, there is a free exercise component as well as a free expression component. Freedom of religion and freedom of expression imply a lack of compulsion or constraint. Therefore, this right may be harmed by policies that force persons to act or refrain from acting in ways that are contradictory to their religion. The provisions of the proposed bill are superfluous because courts already have the ability to consider racial motivation into account as an aggravating factor in deciding sentence. They also superfluous because Section 16(2) of the Constitution is enough to provide remedies in cases where any person goes beyond the scope of Section 16(1). In conclusion, the very possibility of draconian sentences associated with the bill have the potential of forcing our affiliates, who are mostly religious leaders, to self-censor the expression of any view that might upset anyone from the 15 categories of the potential victims. This would seriously stifle the free exercise of our Christian religious beliefs and adhering to the Great Commission. The bill makes it far easier for a person to be found guilty of the crime of hate speech and sent to jail, and could be used to silence critics of either political figures, especially if the powers that may be feel threatened, as evidenced in countries like Venezuela, where leadership of President Chavez and now Mr. Maduro orchestrated the accumulation of power in the execution or executive branch. As a result, there was a widespread erosion of human rights guarantees, and the government was enabled to intimidate, censor, and prosecute its critics, and reported that broadcasters may be censored if they criticize the government. The censorship of freedom of expression or free expression will do nothing to eliminate hate, but will rather drive it further underground and make it harder to identify, to report it, or to act against it. The crux of our argument here, what we would require assistance from this committee, are the following: the definition of hate for the practical purpose of this bill, the definition of formal proselytizing, the empirical evidence to the effect that Section 16(2) is not enough to cover any eventualities relating to the hate speech. And if those can be clearer to us, maybe we would consider. But for now, we do support the spirit of the bill, but not the letter of the proposed bill. I thank you, Chairperson.
Thank you very much, Dr. Mahlangu, for your presentation. Honourable members, do you have any questions for clarity? You can hear me, no? Dr. Mahlangu?
Yes, I can hear you.
You can, okay. All right. Okay. All right. I see Honorable Dodovu. You're on the platform.
Thank you very much, Honorable Chair. I like the spirit of Dr. Mahlangu, even how he articulates issues. It's quite inspiring on a Tuesday afternoon. Now, Honorable Mahlangu, you, as you say, you support the spirit of this bill to deal with hate crime, hate speech, and all of that. But the letter is the one that is problematic. For me, what is concerning about what you say in general is that if you say you are not happy about this definition, or you are not saying, I think the better definition is this one. If you say hate or hate crime, this is what I think is a proper definition. Is the point that I'm raising is the same point that concerns me with regard to the presenters before you. They don't say to us, look at that. We think that with this definition in a broader context, it covers us to a larger extent. And if you just say you don't support it, but you don't tell us in precision what are your views, it inhibits us from really understanding and really consider what is on the table for us. And I would propose the same thing, that please, maybe after this meeting, just write your own proposals about what you think is a proper definition so that Parliament must consider it. That is one point. Proselytizing is not a crime. That's my knowledge. It also applies in that sense. People have got the right to lobby, to canvass, and to campaign, and to encourage people to join their own religion. This is something that we must do it, especially when we do it respecting the human rights, the preferences, the beliefs of other people, and in that context, propagate what you think it is your own religious philosophy and take it forward in that sense. And for me, I want you to understand. I want to understand from you what will constitute politicizing religion as a problem, as a criminal offense. If you can just talk to that, it could be very, very much helpful. Other than that, I'm happy with the submission that you put on the table. It's just food for thought. It makes us to think deep as we continue with this process of public hearings. Thank you very much, Honorable Chair.
Thank you very much, Honorable Dodovu, for the question. Honorable Mikolakis.
Thank you, Chair.
Okay. Honorable Mikolakis.
Yes, thank you, Chair. I would just like to support the request of Honorable Dodovu that some of the amendments that are, or not some of the amendments that are proposed, but some of the proposals that are being made for it to, if possible, come in the form of concrete proposals on possible amendments to the draft bill that I think would help us to at least give us an idea of how to move forward, at least something to consider in that sense as well. So I would very much welcome that request if Dr. Mahlangu is open to that request. Thank you.
Just to be clear, honourable members, it would be the definition of hate and the definition of formal proselytizing. Oops. Yes.
Chairperson, any such proposals I think should be welcomed.
Okay. No problem. I just wanted it to be clear because he raised those three issues at the end. Okay. Dr. Mahlangu, over to yourself. If you wish to respond and or provide a supplementary response.
Thank you, Chair. I think, firstly, our initial view is this bill is superfluous, meaning that probably we don't even need this bill. It's not only a matter of defining things, because we feel within our constitution and other laws that we have in the country, the issue of somebody who creates hate crime is well covered. But in the alternative, we are more than happy to apply our minds and send our amendments in writing as the things that we are proposing as requested by other honorable members. I hope I'm clear there.
Okay.
Thank you.
Okay, no, that's very, very fine. No, thank you very much, Dr. Mahlangu, for your presentation and for taking this time to respond to questions from honorable members. You are, I think, the last presenter. Thank you. Gershon, do we have Litala Bantu? No, they're not on the platform. Okay. Okay, honorable members, I think it's been a pretty long engagement, and I think rather fruitful one, with stakeholders that made inputs into the hate crimes, hate speech bill. Let me then I'll take this opportunity to thank each and every organization once again, and or individual who made a presentation to the committee. And let me also thank committee members for their engagement on the submissions that were made. Our members, we scheduled then tomorrow to meet at, is it 9 o'clock, Gershon? Just to confirm the time.
And that's correct, Chairperson. I'll be sending the link out immediately after this meeting.
All right, no problem. Our members, so we'll meet tomorrow at 9 o'clock to continue with engagements of other presenters in terms of submissions to this bill. Thank you very much, our members, and thank you very much to all organizations and stakeholders. The session is adjourned.
Thank you, Chair.